Thank you, Casey. Hi, everybody. My name is Mike Smith. I'm scrolling through the slides here to get you to our front page. I'm Mike Smith with Holland & Hart. I'm joined on this panel by Bob Jensen, also with Holland & Hart, and two distinguished guests that I'm going to introduce here in a minute. The title of our presentation, as you can see, is Wyoming Tax Policy Discussions 2023 and Beyond. But of course, if you're going to talk about the future, you've got to understand where you're at and how you got here. And we are certainly at a much different place this year during this conference than we were a year ago. We went from a pretty widespread understanding that we were falling off a cliff to building a bridge, and building that bridge with a whole bunch of federal dollars that may or probably may not be available moving forward, as well as some local help with $100 oil and $8 gas. But what appears to be a bridge, many of us believe is really a plank, just extending further out into the abyss. So we want to make sure we discuss, understand those problems, what the structural issues are with our tax system, and how it impacts the business community and all the residents of Wyoming. And that's what we hope to do today. As Casey mentioned, we're joined, Bob and I are, by two distinguished guests, Ashley Harpstrith with the Wyoming Taxpayers Association. Ashley joined that organization in 2019 as its executive director. Prior to the WTA, Ashley was the CEO of Goshen County Economic Development Corporation, where she managed a countywide economic development effort, which included Goshen County Chamber of Commerce, the Goshen County Tourism Promotions, Visitor Center, and Main Street Programming. Prior to that, Ashley worked 10 plus years in the business and workforce development field. She currently lives in Cheyenne with her husband, Grant, and two children. When Ashley begins our presentation, she'll focus on tax structure and some of the legislative efforts from 2022 and what we might expect in the coming session. Betsy Hale is the CEO of Cheyenne Leads, a position she started in April of 2020, smack dab in the middle of the COVID crisis. Before that, most recently, Betsy served as the president of Three Rivers Development Corporation, located in Corning, New York. Three Rivers is a 54-year-old economic and community development organization that serves a three-county region in the Finger Lakes wine country. Prior to New York, Betsy worked for several years as city manager in Loveland and as their economic development director. Betsy earned the designation of Certified Economic Developer from the International Economic Development Council in 2020. We'll have Ashley begin the presentation, Betsy will go second, and then we hope to have time for questions afterwards, and we'll be joined then by Bob. So with that, Ashley, we look forward to your presentation.
Hey, Mike, if you can cue up my slides. So thank you for including us today in this tax conference with Holland & Hart. I thought I'd start with a little humor since you guys are going to be talking taxes all day, since honestly not many people like to talk taxes, maybe not on this group. We're all probably a little bit of a tax nerd, but anyway, so we'll go to the next slide. What is the WTA? I think it's important for you guys to understand where we're coming from so we can present fair and accurate information. But since 1937, WTA has advocated for sound tax policy for a healthy Wyoming economy. We are not anti-tax or pro-tax. We are a nonprofit 501c4 corporation, think tank with a 501c3 foundation research arm. Our membership is diverse from large companies to family businesses, mineral producers to ranchers, corporations to cooperatives, elected officials to private citizens. WTA's Cornerstones of Taxation provides a litmus test for all tax policy that stands on four key principles. This tool helps Wyoming policymakers pave the good road to sensible solutions to tax policy questions and promotes good tax policy for proposed legislation by asking, is it justified? Is it equitable? Is it stable? And is it transparent? This model helps the WTA in determining its position to support or oppose legislative issues. WTA believes sound tax policy is the foundation for economic development. Everyone has a voice in the process. Members benefit from the input of all members, not just a few. The WTA works in cooperation with other professional associations, working jointly on issues to support the best interest of the taxpayer. So a little bit about where we've been to understand where we're going. Tax Reform 2000. Since the inception of the severance tax in the 1970s, Wyoming's tax structure has been beholden to the boom and bust nature of our legacy industries. By the late 1990s, the writing was on the wall as there are major deficits and rising costs of education. In 1997, WTA Executive Director Michael Walden Newman collaborated with Governor Jim Geringer's office to create a discussion on Wyoming's tax structure for the WTA annual meeting. The debate was, if we started from scratch, what would it look like? If we implemented these changes now, how different would the finances of the state look? Post-meeting, this discussion moved forward as the former executive director wrote a draft bill to create a tax committee appropriately named Tax Reform 2000. This special legislative tax committee created bipartisan recommendations. All those recommendations stay the same for today. Wyoming's tax structure is inequitable, unstable, lacks balance, and the tax at the time was almost 75% of the state's tax revenue, which was generated by property tax, severance taxes, and sales and use tax from the minerals industry. So let's fast forward to today, 22 years and counting. Sad to say, much remains the same. However, we have slightly moved the needle. 32 actions have been taken by the legislature based on recommendations from the Tax Reform 2000 Committee, and there have been about 50 to 60 additional bills debated and introduced, but have ultimately been defeated. You can find more information about this all online on wyotax.org. Next slide. Okay, get through our polling questions.
Well, yeah, so folks, we've got our first poll question of the day. You can find that, I believe, on the right side of your screen. We'll give everybody just a second to answer the question, what's the largest component of Wyoming's tax structure? Ashley's going to give you the answer here in just a sec.
Okay, so the major components of the Wyoming's tax structure. What do our revenues look like today? Everyone in the state, I think, understands we enjoy no individual or corporate income tax, so we rely heavily on property and sales tax. In fiscal year 2019, 41% was raised through property tax, which 47% of the property tax was accounted through mineral production. General sales tax accounts for 31%, while severance tax accounts for 21% of Wyoming's revenues. Other taxes equate for about 7%, which include things like fuel tax, cigarette and alcohol taxes, insurance premium taxes, franchise taxes, and the wind generation tax. So how do we spend that revenue? According to the Economic Analysis Division and the State Department of A&I, the three-person family with an income of $65,000 and owning a home valued at $270,000, the average tax collected is $3,500, while the public service costs account for about $27.90 for services, which include things like law enforcement, public works, leisure and rec, transportation, and healthcare and education. To simplify that equation, know that every dollar the average Wyoming citizen pays in taxes results in $7.74 in public services. I would like to note this does not include federal funds. In 2020, Wyoming citizens and businesses sent over $6.4 billion to the federal government and received back $7 billion in payment for things like employment services, support of our parks, federal matching dollars for roads, etc. This explains there is an overall low personal tax burden at the state level. So what does this mean for economic development and diversification? After thinking about this previous information, it makes one wonder, what does it mean for the state's revenue if we do diversify? Those were the exact thoughts of the former revenue chairman, Mike Madden. He wanted to draw out the data to quantify changes in our local economy. In June 2018, Regional Economic Models Incorporated, otherwise known as REMI, presented fiscal impacts of economic diversification under Wyoming's current tax structure to the Joint Revenue Committee. looking at 4 different industries: oil and gas, chemical manufacturing, utilities, and food manufacturing, namely in agricultural products, and then comparing existing tax structures in Wyoming and other similarly situated states like Utah, North Dakota, and Kentucky. Remy said, under its current tax structure, Wyoming effort to stimulate non-resource sectors in the state presents fiscal challenges. Only growth in resource sectors has significant positive fiscal impacts. So taking this information, it's helpful to understand the state's tax structure and revenues, as this graph illustrates how this plays into state budgeting. This is a 20-year snapshot of the state's general fund. The bar graph illustrates the state revenues, while the line above notes the appropriations, which please note this does not include the school foundation program, which funds K-12 education. That is a discussion for another day. But as we look at the 21-22 biennium, we started with a $2.96 billion budget. After the pandemic hit, we went to 0 rigs for the first time in Wyoming history. The governor immediately implemented a hiring freeze and 15% cuts in the fall of 2020. At the 2021 general session, due to the pending $1.9 trillion American Rescue Plan Act, otherwise known as ARPA, consensus was drawn quickly between the Senate and House for fiscal year 21-22 supplemental budget. This stayed very close to the governor's original recommendations of about $430 million in cuts to general fund, which brought it from $2.9 billion to about $2.5 billion, with the elimination of 324 predominantly vacant positions. In total, this equated for a 39% decrease compared to $4.1 billion of spending 10 years ago. The 23-24 biennium budget, which will begin on July 1st, 2022, Governor Gordon recommended a flat budget of roughly $2.9 billion. This past 2022 budget session, the Joint Appropriations Committee worked closely with Governor Gordon's recommendations and presented the legislature with approximately another $2.9 billion general fund budget in the form of 2 mirror bills, Senate File 1, General Government Appropriations, and House Bill 1, General Government Appropriations 2. After it ran through both chambers and everything signed into law and the dust has settled, the final budget for fiscal year 23-24 is appropriated at $3 billion. Continuing on to the 22 budget themes, the Legislative Management Council set the tone early on and announced 4 top priorities to take precedence over the session. 2 of the 4 priorities were constitutionally required: the 23-24 biennial budget and redistricting, while setting capital construction as a top priority and appropriating an unprecedented amount of $1.086 billion in federal funding from the American Rescue Plan Act. On priority 1, per previous comments, the legislature passed a $3 billion budget. Per the Consensus Revenue Estimating Group, otherwise known as the CREG, the April 22 long-term revenue expenditure forecast, the School Foundation Program and School Capital Construction Account will be funded at about $2 billion, with a projected shortfall of $128.1 million to be backfilled by the Legislative Stabilization Reserve Account, otherwise known as the LSRA or the Rainy Day Account. The LSRA was left in a surplus of $1.43 billion as the estimated balance on June 20th, 2025. Note that this can change with actual revenues and reversions at the conclusion of the budget. Party 2, which was heavily debated and appropriated through Senate File 66, American Rescue Plan Recovery Funds Appropriations, everything but $72 million of the $1.068, I flipped the number earlier, billion dollars was allocated for ARPA designated for state fiscal recovery. Priority 3, Senate File 67, state-funded capital construction appropriates funds for specified capital construction state projects. The $249.3 million appropriation stayed intact with a few amendments, which brought the total to $252.48 million, with adding $2.8 million for state parks land purchase and $250,000 for a state constitution display in the Capitol. Additional funding of $190.8 million went to miscellaneous state construction projects, and $58.6 million went to University of Wyoming as a block grant to fund the Corbett Natatorium, War Memorial West Stands project, and College of Law renovation. Priority 4, the legislative debated maps until the last minute, settling on a final plan that creates 62 House and 31 Senate districts. As far as the overall theme of the session and additional tax considerations, typically in a budget session, the Legislative Service Office will see 500 to 600 requests. This year, thanks to the 4 priorities, of the 451 requests, the legislature considered 279 bills. We tracked 59 of those with fiscal impacts. Highlights include, I'm not going to read them all, but just quickly, House Bill 21, repealing exemption for one-way pagers, now House Enrolled Act number 2 has been signed into law. The reason this is important is it removes sales tax on service for one-way pagers. Even though the fiscal note is de minimis, this is a start to looking at the 50+ exemptions on the sales tax base. Fiscally responsible bills for special district passed both chambers. There are several attempts for tax reductions. However, 2 attempts successfully passed. House Bill 131, Nuclear Power Generation and Storage Amendments, now House Enrolled Act number 59. The House amended in an exemption after July 1st, 2035, using 80% of uranium sourced from the U.S., or they will be subject to a $5 megawatt hour tax. Also, House Bill 105, Severance Tax Reduction Coal, freshly signed House Enrolled Act number 60, reduces severance tax from 7% to 6.5%. This was a huge win for the coal industry to bring equity and parity to severance tax rates amongst minerals, and also a Tax Reform 2000 recommendation. Bills that failed, no doubt, will be back.
Oh, now we're on to our second polling question of the presentation. How many bills were considered in the 2022 budget session? We'll go ahead and move on to the next slide here while you all consider your response. Thanks.
Okay, and so I just wanted to present a snapshot of how especially different this year was as the state received all of this discretionary funding from the federal government. These were the amounts totaled going into session. These amounts have changed and have increased. Since then, more federal stimulus dollars have been released, such as the Infrastructure Investment Jobs Act, otherwise known as IJA. But the individuals' accounts were direct payments that individuals received, businesses accounting for the PPP loans that they might have taken advantage of, and then governmental entities direct payments from the federal government of that $4.5 billion, the $1 billion of discretionary funding that came to the state. Other local entities received similar direct funding. So going into session, the state had received over $8 billion in funds. Okay, so looking forward to 23 general session, the 22 interim will stay busy for this part-time legislature with full-time issues. Many of the issues will stay the same as revenue addresses 15+ policy consideration with 5 from last year's topics. Other topics like gaming and K-12 funding will be discussed in multiple committees, and new topics like investments as a source of revenue and exploring the use of virtual currency for tax collections will be new discussions in the interim. Next slide. Please feel free to reach out to me directly if you have any questions about upcoming policy considerations, as we will continue to prioritize committees with revenue impacts, budget and expenditures, including expenditures of federal monies and monitoring alternative revenue sources. Thank you.
Thank you, Ashley. We're going to ask folks to, well, I started to say hold your questions, but there's no need to do that. Please use the chat function or the Q&A function on your screen to start logging questions. We'll wait to have the whole panel address those questions at the end of Betsy's presentation. So please feel free to enter those questions and we'll circle back to them. There's some resources on the slide deck in case you're interested in looking into some of the things that Ashley discussed and some of the resources you can have online. Okay, so now we'll move to Betsy Hale, who's going to discuss a recent study and the impacts of Wyoming's tax structure on competitiveness for economic development. Betsy?
Good morning, everyone. Hope everyone can hear me okay. First, want to thank Holland and Hart for inviting me to participate in this, and Bob and Mike for your advice and guidance as we prepared for today. Ashley, a great job kind of teeing me up for this. I'm going to get a little more specific and granular than what Ashley was. And then I know on the call today, I have some of my board members from Cheyenne Leads, and really want to thank them because it's with their vision that Cheyenne Leads has been around since 1986. And we can go ahead and start the presentation, Mike. Okay, there's another poll.
Yes, yes. Here's our next polling question, but we'll move right into Betsy's
Okay.
presentation and give you a
So,
second to answer that. Thanks.
as I was saying, Cheyenne Leads was started in 1986. We are a private economic development nonprofit. Really, it was the vision of these business leaders that got together. They raised about $3 million, and their motivation was that we did not have any shovel-ready sites here in Cheyenne, and Walmart came a-calling and needed a place to put a dry goods distribution center. And today that distribution center is down in Loveland, Colorado at the intersection of I-25 and Crossroads Boulevard by the Budweiser Event Center. But it could have been in Cheyenne had we had a business park where they could have been located. And so that was really the motivation for this group of citizen leaders to get together. They purchased 900 acres east of town over what we call now the Cheyenne Business Parkway. They did this again in 2004 when they purchased 600 acres over on the west side of town, which is now called the North Range Business Park. And incidentally, there is a nice Walmart refrigerator freezer distribution center located there. So it's working. And one of the things I'd like to commend our board on is that they are very fiscally conservative. They always want to justify to their membership and those folks that put money into the business parks what the return on investment is. This past year, we had an ROI study done by the University of Wyoming Center for Business and Economic Analysis. And for every dollar that went into the purchase of the land and the infrastructure, sewer, water, and fiber to make, and roads to make those shovel-ready sites, we've received $5.60 return to the state of Wyoming. And how we use this as an incentive, some of the companies that are located in the parks have received the land for free. Some of them have received them at discounted prices. So for example, Lowe's, Sierra, EchoStar Dish, the land was given to them for free. Microsoft's first facility on the North Range was the land was given for free. And then this past year, they purchased land from us at a discounted price in the Cheyenne Business Parkway. So those 15 companies that have received land as an incentive generate about $213 million in annual GDP for the state of Wyoming. And that just continues to grow as we continue to bring more companies to the parks. And also we've just started another park. But here's the dilemma, right? We're running out of land. And so how do we compete? Cheyenne Leads is the attraction organization for Cheyenne and Laramie County, and we work with site selectors like KPMG, Ryan, Ernst & Young, Jones Lang LaSalle, PricewaterhouseCoopers, and others, real estate organizations. And they'll go ahead and they'll, for the company that's looking at sites across the country, across the globe, they'll look at those ongoing costs of operation, everything from taxes, labor, utilities. Then they also factor in the mitigation of those costs through incentives. And we'll talk a little bit about incentives, but one thing you all know in Wyoming is we are not an incentive heavy state. As I always tell prospects, including one I talked to yesterday, if we don't take your money, we can't give it back. So ultimately, we care about tax policy and tax structure in Wyoming because we create our messaging from data and we target companies that benefit from our current business climate. Go ahead, Mike. Okay, so why did we do a study, or why did we engage the Tax Foundation to do a study on Wyoming's competitiveness? Well, we believe that we need to understand how we compete in the United States with the 50 states and District of Columbia. And we felt like the Tax Foundation, who, by the way, Ashley brought in for her annual meeting this past year, we felt like they were a trusted third party that we could bring in to look at this. They brought along KPMG when they did their Location Matters study, which is a nationwide analysis. There's a link to this full report on our website. What they did, and it's really relevant, is they designed 8 model firms, and they calculated each firm's tax bill in all 50 states and the District of Columbia. Now, they did not include extractive industries. And so this was really important for us because in Cheyenne and Laramie County, we're trying to diversify the economy and become less dependent on the energy side of things. So the 8 types of companies they looked at were corporate headquarters, technology facilities, data centers, labor-intensive manufacturing, research and development, distribution centers, capital-intensive manufacturing, and shared services, which is like credit card processing, call centers, et cetera. And then they also looked at the balance of taxation, which you've heard from Ashley already, of where does the burden in the state lie, business versus personal. So each firm was actually modeled twice. One is a new firm, something that we'd be attracting, and then one as a mature firm, a company that's already here, an existing employer. Typically in economic development, you'll see, if you're familiar with H2Q, like Amazon, when they were looking at another headquarters, you'll see a lot of incentives piled up to bring companies to states. And then you don't see as much for business retention expansion. Wyoming is a little bit unique in that. So what did the study show us? And this is really good news, so it's exciting. Wyoming offers the lowest average effective tax rates for mature businesses. So this is great for companies that are already here, and the 7th lowest for new firms. So when you look at this on the surface, it's like, okay, this is really good. This is where we want to be as an economic development organization. In fact, every mature firm type in Wyoming ranks in the top 3 nationwide for the lowest effective tax rate. So if you're just looking at taxes, sounds pretty good. Now, what we know at Cheyenne Leads is that the sales tax exemptions, which data centers and manufacturing firms can qualify for on their equipment, is working, okay? And it works because it works for both new companies and existing companies, companies that have been here. So what companies, I don't know if you understand what data centers do, but every 3 to 5 years, and I know there's maybe some folks on here from Dish, I don't know if there's anybody here on from Microsoft. Every 3 to 5 years, they have to replace all of that equipment, and it's millions of dollars. And so these sales tax exemptions really make it favorable to do business in Wyoming, to come to Wyoming, and to stay in Wyoming. So, and in fact, in the 10 years that we have had data centers, actually that we've had Microsoft here, all of the data centers, and that's just not just Microsoft, actually Lunavi, Greenhouse Data, EchoStar, Microsoft, VMA Cell, and others have put over $2 billion of capital investment here. Just last year, the last 6 months of last year, Microsoft's new facility that's being built in Cheyenne Business Parkway, according to the building permit that was with the city, they've invested $420 million, and that facility is not even open yet. So we do know that the sales and use tax exemptions on equipment for manufacturing and data centers work. It's why it's important to keep them. The Data Center Cost Reduction Grant, which is a reimbursement for the power and IT cost, is effective. It's not a huge incentive, but it is one that really helps. Everything helps when you're trying to compete. The other thing we do know is that diversification is our future as the energy economy changes. And just last week, Bob and I were at the Next Frontier Energy Summit, and it was just very exciting to see large corporations. I think there might be some folks from Exxon on the call today, really doubling down on Wyoming's energy economy, everything from our traditional coal, oil, gas, right through to hydropower, hydrogen, nuclear, everything that's going on with TerraPower. But again, as Ashley just said, I think economic diversification efforts are unable to improve revenue flow in Wyoming without tax reform. So next slide. So this sounds good when we look at our effective tax rate and how we compete, but 26 other states in the US offer incentives based on investment. So remember that $2 billion of capital investment. 20 states and the District of Columbia offer cash per jobs. And in fact, some of you may recall the Foxconn incentives that were offered in Wisconsin through the governor and the president. And that was anywhere from $100,000 to $200,000 cash per job. So pretty phenomenal competition. There's also percent of payroll incentives that can go anywhere from 2 to 10 years. 45 states that we compete with offer property tax incentives, which are really highly discretionary, which means they can be forgiven, rebated, abated, you name it. All of it can be done. West Virginia actually offers data centers up to 95% of an abatement of those personal property taxes, which is all that replacement of equipment. Kansas is actually 100% abatement for as long as 10 years. So you can see, while we have some really good tools in Wyoming, our tools are not always able to measure up. That's why it's important to keep what we have. 37 states offer incentives for R&D. We have no R&D incentives in the state of Wyoming. And then 15 states offer withholding incentives or percents of payroll. So there's some balancing act that has to happen. So what is the concern? I think I've alluded to it. I've been here 2 years, as Mike said. There have been legislative efforts both years to eliminate those sales tax exemptions for data center and manufacturing equipment. If those were to go away, we actually were meeting with a large data center company yesterday, not Microsoft, and they just flat out said if that sales and use tax exemption were to go away, they probably wouldn't be looking at Wyoming. And so it would make us less competitive. Now, the other thing that it would do is it would hurt our existing companies. So it would hurt the Lunavis, it would hurt EchoStar, it would hurt Microsoft and VMA and other companies that are coming and making their home here. And so it's really important that not only do we think about bringing, it's about keeping. So the other startling factor, which I think Ashley again alluded to, and even Tax Reform 2000 pretty much put out there, is that in Wyoming, 70% of our state tax burden is placed on business. And the average around the country is about 44%. So if we continue to put more burden on business and industry, we will clearly no longer be able to compete and diversify our economy as the businesses have to take this burden on. And so the other thing, and I know you all know this because I know there's a lot of energy folks on the call here, is and actually I loved your comment there, Mike, about bridge versus plank. You know, if the extractive industries continue those boom and bust cycles, and what about inflation? What about politics? What about war? How do we see the energy transformation happening? Can Wyoming continue on this structure? So next slide, please. So this is the most important piece of the study that was done by the Tax Foundation and KPMG, and it really shows this imbalance where nearly 70% of those tax revenues in 2021 were coming from business and industry. And so how we swing the pendulum, I don't think I have any answers. We want to be supportive. This is all available again at CheyenneLeads.org. Next slide, please, Mike.
You can interrupt your presentation for our next polling question. What makes up the largest share of Wyoming taxes? You've got 3 different choices there. Just give people just a second to respond.
So with that, and I think you all probably aced that test, we are in this, and our board supports studying these kinds of things, and continually we'll be working with Ashley and taxpayers because we believe research and data helps us guide and drive our investments. It helps us understand what we need to do to continue to diversify the economy here in Cheyenne and Laramie County. We do know that tax structure matters. These site location decisions are made based on the tax climate, and they are also made based on incentives. And we know constitutionally we aren't able to do a lot of those things that other states can do. What we do know too, as we do our business retention expansion surveys, is that our employers, existing employers, count on predictability of the cost of doing business. And of course, taxes aren't the only issue, but they seem to be one in the forefront very often. And like Ashley said, it's an election year, so you just never know. So we're excited to participate in future conversations. Again, there's our website. You can go for links. And the one thing I do want to leave you with is a quote from Nick Kolish, who was is the editor and lead researcher for LCCC, Laramie County Community College's Center for Business and Economic Analysis. In March, he released our annual trends. And his quote toward the end of his executive summary was, "Looking to the future, the most significant economic issue in the state of Wyoming, and to a lesser extent Laramie County, is the long-term prospect of decreased tax revenue due to a lower energy price and the decline in energy extraction activity in the state. Just the uncertainty around this issue created significant issues in the recent Wyoming legislative budget session, as Ashley mentioned. At each level of government, state, county, and city, new sources of tax revenue will need to be identified and/or fewer services provided to residents." Thanks.
Thanks, Betsy. And I'll invite Ashley and Bob Jensen with Holland and Hart to to join the discussion now as well. Please send your questions to us all through the chat or Q&A function. And I'll start things off with Betsy. Your organization, Cheyenne Leads, has had some real exciting announcements in the last year, even last 6 months. Can you give us a brief, overview of some of the successes you've seen? And obviously we have some challenges, but there's some good things going on and that make Wyoming and Laramie County attractive. And maybe you could touch on that as well a little.
Sure, happy to do that. Our most recent announcement was just at the beginning of April, and it is Ulrich Manufacturing. They are a 4th generation manufacturing company out of New Zealand. So this will be their first US location. They are a company which manufactures not only fencing, but they manufacture the equipment that manufactures fencing, and then they service the equipment. So they have US customers for not only their fencing, but also for their equipment. Very exciting, again, manufacturing equipment, sales tax exemption, right? Right before that, we also announced Eagle Claw or Wright McGill. Eagle Claw is, again, another 4th generation family-owned manufacturing business. Probably most people on the call utilize their fish hooks when they go fishing here in Wyoming and Colorado. And really exciting, they're currently located in Denver. And I'll just tell you what Drew McGill told us the first day we met with them. They said they were a red company in a blue state. And I mean, they didn't care about taxes. They needed to relocate out of downtown Denver, basically. If you know where they are, they're at I-70 and 25, and it's just not a good location for them. So very exciting. They're going to break ground first quarter of next year, so we're excited about that. We also have, again, the 2 Microsoft data centers. So there's a large data center on Highway 85, and then the data center going on in Cheyenne Business Parkway. And then, of course, the data center continues to grow out in North Range. And frankly, I don't think it's any surprise to anyone. We anticipate with all of our data centers that are existing and with several others that are in addition to the Microsoft data centers, about another $10 billion of capital investment in the next 5 to 7 years.
It's awesome. This next question is really to all 3 of you, Ashley and Bob and Betsy. Wonder if you can give more detail about the tax structure imbalance and what it means for Wyoming, and do we see any effort to address it? Tax reform 2000, here we are 22 years later, and we're still talking about some of those same issues. So what's it mean, Ashley, that imbalance, and is there any effort to do anything different?
Well, I'm going to comment like Betsy did on your initial statement. I mean, that's why I have job security. It's the same discussion we've had for 50 years. We're walking out on a plank, and those slides I put out there about the cost of services versus the personal burden. I actually have my little intern here from University of Wyoming, and I was explaining when Betsy was talking about the cash advance of $100,000 per job because economic development is based off jobs. That works for every state but here. Because our personal burden is so low, it costs us money when people come to our state. We could never dream about that. We actually cringe when people come. Well, legislators cringe when people come here. We, of course, do not. So until that balance is more of a personal versus business balance, and it's a high tide lifts all boats, our services are going to have to be cut. And that was why I made such a effort to talk about the cuts that they have imposed over the last 10 years. They realized that, so they've been doing everything they can to cut, which is almost to 50% of the general fund budget. And again, K-12 has to kind of remain in its own silo. That's a different discussion for a different day, but everything else has been cut. And then they have to start looking at different levers to raise that base, but they're not there yet because we have rainy day funds and we have $1.43 billion in savings. Nobody wants to do taxing and incentives. It's not friendly for elections. So it's a matter of kicking the can down the road. What crisis are we going to hit next? And then boom, we get out of it again. So we're just really good at walking that tightrope.
Mike, I'll follow on with that. One of the reasons that we, economic development organizations don't typically get this deep dive into tax questions and tax structure and tax policy. It's just one of those things we try to let Ashley take care of. But when our manufacturers and our data centers are being faced with things that could substantially affect their cost of doing business in Wyoming, we felt like we really needed to get involved. And with the over-reliance on, one sector for revenue, we also believe that our role in economic development is really work on diversification. Ashley nailed it. One of the reasons that we're kind of bullish on data centers is they have high capital investment and a low number of high quality jobs, right? And so she talked about a $65,000 household, and typically starting wages at most of these data centers are well over 75, 80, in some cases 100,000 just for technician positions, not to mention those really qualified HVAC, sheet metal workers, because construction is always going, right? So that's what's been working for us, is that we haven't had 600 employees. We've had 100, or 50 or 75 at a time. Because you do have to have places for people to live, right? You do, and we have an incredible housing shortage. So I think, trying to always bring high capital investment, high quality jobs as opposed to a large number of jobs will help. One of the things I do want to add is that we do run an economic analysis called Site Stats, and we actually forecast net new revenue. So we try to see the impact of not only the company, but the employees from not only the plus side, but also that cost of service delivery that Ashley talked about with the $23,000 per household versus the $3,000 tax coming in. Typically, when we run these, the city looks really good. The county looks great. Microsoft is the largest property taxpayer in Laramie County. But the state, those numbers come out red very often, very often. And so I think what Ashley and I are going to continue to try to do is very quietly and gently nudge, not necessarily poke the bear, but nudge, so that at some point in the future, we can get our elected officials and citizen leaders to take this on.
Mike, I'd like to weigh in a little bit on this, and thanks for you guys being here. That was a terrific presentation. I appreciate that. We've been working on diversifying Wyoming's economy since Wyoming's been an economy. And we've made some progress on that, and we love the extractive industries. We appreciate what the oil and gas and the coal and minerals do for the state of Wyoming and what they have done and what they'll continue to do. But we do have to be cognizant of the other industries that are out there and have a diversified portfolio of businesses that create a wide variety of jobs and provide a diversified tax base to support the services that the people that work in those jobs consume. And so the focus on trying to diversify the economy essentially rests on how can we be competitive with our neighboring states and with the whole country, and actually with the world. This is a global economy, and we have global companies that exist here in Laramie County and in Wyoming. And we have to remain competitive and be more competitive when it comes to allowing those businesses that are already here to stay competitive with their competitors, and we have to be competitive to attract those companies here to grow the economy. And the fact of the matter is that when we're looking at an unbalanced tax structure like we currently have and have had forever, it makes us less competitive. But what it does show is that there's room. If we do need to raise revenues and have a more stable revenue source, we can do that by having the people that consume the services pay a little bit more for the receipt of those services. And there's room to do that. And in fact, if you look at the chart on the ratio of what an individual pays, what an individual family pays, for taxes and the services they receive. If you look at that ratio over time, it has actually gotten better. And we are paying a little bit more for the services that we receive. But the truth is that if we want to be competitive, if we want to diversify our economy, and if we need to have new revenue sources to pay for increased costs of government, and particularly the cost of education, which is where the real nut is, we are going to have to be willing, as a resident of Wyoming, Cheyenne, and Laramie County, am going to have to be willing to pay more for the services that we receive. And that's just a fact of the matter. And the problem with that is we vote and businesses don't. And so it's hard for politicians to accept that. While they all talk about wanting to diversify the economy and wanting to grow the economy, none of them actually really care about trying to make tough revenue decisions where actual people are going to have to pay more, even though we have the capacity to do that based on some other studies that have been done most recently by Laramie County Community College. So the solution is there. There is room for a more balanced portfolio of tax revenue. It's just a matter of the political will to be able to accomplish that.
So one thing that jumped out at me in a big way, Ashley, from your presentation, I think I have these numbers right, correct me if I'm wrong, but the next biennial budget sits at about 3 billion. And the number you stated as far as federal monies coming in over the COVID period as 8 billion. So we got $8 billion in federal money for a budget, a 2-year budget cycle of 3. What happened to that money in broad terms, and did any of it go to efforts to shore up the issues we're discussing today?
Unfortunately, it created a false economy, just like we're seeing in other areas of our lives. It allowed us to push things out. I was in the state budget officer's office yesterday, and just working with staff in the state, trying to understand, like, where is that number? What's that number look like of how long the plank is until we're faced with reality again? And normally we could have done some simple math to kind of figure that out, but this really created a buffer around it. So it was a revenue replacement, the one that the state got. So that was great. So we were able to basically backfill our LISRA and have the 1.43 billion, which this time last year we were $1 billion shortfall. So it's just been extremely drastic. Dr. Godby did a presentation from University of Wyoming College of Business with me a couple days ago, and he always starts with dogs on a roller coaster. A, because he loves dogs, but B, because that's the way it is. And he's on the consensus revenue estimating group. I mean, it's just so up and down. So it just, the term that we like to use, that I know the panelists know this well, is that it just really kicked that can down to the other end of the block, and just created a false sense of security. It does buy us more time. I mean, as an individual, I enjoy my low tax base. I know it's coming. And the levers we're talking about are minimal. If they did try to create equity there, they've worked really hard in cost savings. The last cost savings I think that's left is that we keep talking about, but putting it in a box is K-12 education. That really hasn't seen the cuts as all the other areas of government. And that truly is the problem. Back to that Remy slide, for every 100 jobs we bring in outside the minerals sector, that's what's costing us, is to educate our kids. And no, like, I don't think anybody on this call would not believe in education. So we know it's something we have to pay for. We just got to figure out that right size. We've got to think about some personal taxes and that are low and broad base. And eventually we could get there, but it's going to take rolling up the sleeves and digging in and not being scared about being reelected.
Bob or Betsy, any final thoughts on that?
Well, I think what Ashley's alluding to is there's going to have to be maybe a tax reform 2023 or something like that. What I hear from our businesses and even our board members is they don't mind paying taxes, right? They get it. It's their fair share, their businesses need services, reliability, police, fire, all those great things, good roads, wonderful parks, those kinds of things. But they also write paychecks and payroll, right? And those dollars then go to stores through their employees that create more taxes. So they really feel like they're putting their fair share in by paying taxes, but also by paying people that go spend money that pay taxes. So I think that if we can get to a point where first we have the conversation and it's a really civil one of just here's the facts, but then it's also one of vision and what do we want our kids to be doing in the future, solving it for them and our grandkids. I think that that's probably the approach that we'll have to take, is all Wyomingites getting together. And the nice thing is there's 570,000 of us and half of them probably don't vote. So the kids anyway. So hopefully we can get some folks in the room and roll up our sleeves, like Ashley said, and get it done.
Got about a minute, Bob, if you have any final thoughts.
Well, just again, let me thank you, Mike, and thank everybody at Holland and Hart to put this on, and thank particularly Betsy and Ashley for participating in this. It is an interesting dilemma that we are in Wyoming, but I will say this, I'm very optimistic about the future for Wyoming. I do think that we will make efforts and be successful in moving towards a more balanced tax structure. And I'm very optimistic about the economy here going forward. We have some unprecedented opportunities here for the state of Wyoming and Laramie County that we can grab a hold of and really make a huge difference in how our state looks economically going forward. So I'm really optimistic and appreciate all the work that these folks do to help that move forward.
Well, I'd like to thank you all as well, and appreciate everyone tuning in. And Casey, back to you.
Thank you.
Thanks, Ashley, Betsy, Mike, and Bob. That was a very informative and interesting presentation. We're going to take a quick break and we'll reconvene at 9:50. Welcome back, everyone. Next up, we have a panel consisting of Carl Anderson, Walter Eggers, and myself, Casey Schluter, and we will be presenting on how to prepare for an audit, as well as providing an update on contested cases, appeals, and hot topics. So we're going to start off with a polling question, and it's a pretty easy one. Have you ever been through a Wyoming state audit? And it's just a quick yes or no. And just a quick reminder, if you are going to apply for CPE credit, it's important that you do answer these polling questions. And while I give you a chance to answer that, I'm going to just introduce the panel here. Carl Anderson was in private practice for 5 years before joining the Attorney General's office. At the Attorney General's office, Carl has focused on state tax law issues, including representing the Wyoming Department of Revenue in front of the State Board of Equalization and in state courts. He is currently a supervising Attorney General in the Civil Division of the Attorney General Office. Walter Eggers is a partner in Holland and Hart's Cheyenne office, and he advises and represents clients on state and local tax matters, as well as energy-related issues in front of the Wyoming Board of Equalization and in front of state and federal courts, as well as in front of the Wyoming legislative committees. As for me, I'm an associate with Holland and Hart in the Cheyenne office, and I advise and represent clients on state and local tax, as well as commercial litigation issues in front of the Wyoming Board of Equalization and state and federal courts. And now I'll turn it over to Carl to discuss how to prepare for a state tax audit.
Thanks, Casey and Walter. I appreciate the opportunity to talk to everyone today. So if we can go to our first slide here, as I'm sure everyone is aware, Wyoming is a self-reporting tax system, at least when it comes to mineral and excise taxes. And because we're a self-reporting system, verification is done through the auditing process. And the goals, at least the way I have seen them over my years of representing both the Department of Revenue and Audit, are really threefold. The first goal of an audit is obviously compliance. We want to make sure that the taxpayer, as well as ourselves, are conforming to what the legislature has directed us to do in regards to taxation. And since we are a compliance, or this is a compliance audit, it doesn't really matter to us where the error is. If the error is an overpayment by the taxpayer, then we're going to come to a finding of a refund or a credit. On the other hand, of course, if there was an underpayment of taxes during that time period, then an assessment is going to be made. But we're a compliance state, and obviously if we have an audit and it looks like a credit's going to come, we're not going to shut down the audit to just generate revenue. The second goal that we have is education. We want to make sure that the taxpayer, through the auditing process, identifies issues that they may have in reporting their taxes and are able to correct those going forward. We realize that the audit itself is going to be of a limited time frame, but the taxpayer and your clients are going to be in business for a long time after that. And we want to make sure that everyone is able to correctly report any errors that have been made on a go-forward basis, or able to make those corrections. And the final auditing goal that I see is uniformity. We want to make sure that all like taxpayers report consistently to one another. We do not want to have any sort of economic advantage or disadvantage to a particular taxpayer. We similarly situated taxpayers, we want to have them report in the same fashion as those that are being audited. So those are the three main goals that the auditing process seeks in the state of Wyoming. Now, the next thing I want to talk about is the difference between the Departments of Revenue and the Departments of Audit, as well as some educational resources that are available to taxpayers. So the Department of Revenue is the sole valuation authority in the state of Wyoming when it comes to statewide assessed taxes. Mineral taxes, excise taxes, tobacco, wind generation taxes, those sorts of things. The sole valuation authority is with the Department of Revenue. The only real exception to that are fuel taxes. That's administered by the Wyoming Department of Transportation. And the Department of Revenue is that sole valuation authority. They're the only state agency that's able to tax individuals and to make taxability determinations, obviously. However, if you are the subject of an audit, you're actually going to be audited by a different state agency. You're going to be audited by the Wyoming Department of Audit. They're separate from the Department of Revenue. They have their own director, their own administrators, their own employees. And they essentially work as a fact finder, an investigator, if you will, for the Department of Revenue. Now, you may be thinking this just sounds like a bureaucratic organization or organizational scheme, and you're absolutely correct. It is that way, but it does have some very practical effects on taxpayers. And I think it does lead to some confusion, especially for taxpayers that are being audited for the very first time. And that confusion comes from the fact that your auditor that is performing the audit, obviously as an employee of the Department of Audit, doesn't have the ability to make final determinations about taxability or not. They follow guidance that has been given to them by the Wyoming Department of Revenue. So typically what you will see during the course of an audit is that if there are substantial questions about interpretation of statute or the Department of Revenue's rules and regulations, any sort of substantive question about whether this particular transaction is with during an audit, your auditor says, look, I'm going to have to go and talk to the Department of Revenue. I'll get back to you on those issues. Or if you want to have a meeting between you and the person who can actually make those determinations. It's going to be a meeting between yourself, Department of Audit, and then someone from the Department of Revenue will be there as well. So just keep that in mind. And obviously, any sort of ultimate determinations that you're going to see from the Department of Audit, whether they come through a preliminary issue letter or their final issue letter, all of those will have been reviewed by and approved by the Department of Revenue. Now, the next thing I want to talk about in regards to this is some of the resources that are available to you to see exactly what sort of guidance really has been given to the Department of Audit, because that's how they audit. They audit to guidance and training that has been provided to them by the Department of Revenue. And you can sort of look behind the curtain, if you will, by going to the department's website. That website, I think, was indicated on the beginning of the slides. It's revenue.wyo.gov. And if you go there, you're going to find links that'll take you to the Wyoming tax statutes and the department's rules and regulations. And you can obviously look at those. Very important documents. They do guide taxation in the state of Wyoming, obviously. But really where I would direct you to, if you have some very practical questions, is that we have a number of bulletins and guidance that is on our website. And they are meant to be, these publications are meant to be in a bit more of an approachable format than just the statutes and the rules and regulations themselves. We have publications that are for specific industries. We have some for agricultural. We even have some for dude and guest ranches, as well as taxidermy. So if you've got specific questions that you'd like to look at, I would ask you to go and look at those publications that we have. And in fact, when you're looking at those, that's the guidance that your auditor during an audit will also be looking at. So oftentimes when there are questions that come up, your auditor may in fact refer you to or actually give you a copy of any of these publications. So if you want to sort of get a step ahead of everything, this is an excellent place to go to look for that stuff. There are also other avenues of education that can occur pre-audit or during the audit or even after the audit from the Department of Revenue. We offer a number of educational opportunities through webinars, just like you're participating in today. Prior to COVID and when we used to have a travel budget, we actually would go on the road and conduct educational seminars in person. That doesn't happen quite as much anymore. We do it virtually now. But it is an opportunity to be trained on a particular subject matter and how to report and how the department interprets the statutes on a face-to-face, or at least a virtual face-to-face discussion. And you're given an opportunity at the end of those to ask employees of the Department of Revenue specific questions that you may have, and they will do their best to try to answer those. The last thing that I'd like to bring up as far as education and looking behind the curtain and seeing how the department would interpret particular parts of the statute is by making a written request to the department for a taxability determination. Particularly in the excise division, we have an entire section of the excise division that is devoted just to education and to answering these questions. And so if you have a specific question, put it in writing, send it to us, and we will get to you a determination of whether it's taxable or not. And keep in mind that we answer not only actual scenarios, but also hypothetical ones too. We understand that when you're planning whether a new business or expanding a business into some other field, that tax implications fall into play in your business planning. So we do answer questions about, if I do X, Y, and Z, will this be taxable or not? What are the tax implications? And we will answer those and get you a written response. And even if you disagree with that, that's a final agency action that is appealable And you can, go to the State Board of Equalization if you don't like our answer, and we can work those issues out. So those are the three areas of education that the Department of Revenue offers you that gives you some insight into what the auditors themselves are looking at. So it looks like we have our next polling question here. And the question is, who performs audits in the state of Wyoming? Okay, so let's move on while you're answering those questions. So let's talk about the audit process itself and what you can expect to have happen. So the first thing that will happen if you are the lucky subject of a Wyoming tax audit is you're going to receive some sort of informal initial communication. This will usually be a phone call or an email from the Department of Audit. And really what they're looking for is, well, first of all, a heads up that there will be an audit that will be being conducted. But mainly they want to have a audit contact person. We want to have someone that is responsible for any communications that comes from the state of Wyoming in regards to the audit. So they're going to be looking for that. And there may also be some initial discussions about scheduling. If auditors want to come out and meet with the auditee, we want to make sure that we're doing that at as convenient of a time as possible with the business. We understand that many businesses will have seasonal busy times, or maybe going through some sort of company maintenance, some turnaround, and we want to avoid that any sort of disruption that we can. We also have to balance our work schedule too. We're doing multiple audits at the same time, but we will work with you to come up with a time that is convenient to you and that works for us as well. And that's the point of that initial informal contact. Now, following that, you're going to receive an actual engagement letter. The audit contact person will get a letter from the Department of Audits, and this is the official kickoff of an audit. There are several statutory deadlines that are in place that set how when an audit can be engaged and for how long. This engagement letter is the kickoff time for that. So it's the official start. In that engagement letter, you're going to have some specifics about the time period that is going to be audited, as well as the types of transactions. If this is a mineral audit, for example, the engagement letter is going to identify the exact mineral groups that are going to be engaged, as well as the production years that are subject to that audit. You're also going to have a laundry list of items that the Department of Revenue would like to have provided to them, either initially or when they show up. These will be tailored, obviously, as to whether this is a mineral audit or an excise audit, but they're going to be things such as a chart of accounts, field schematics if we're talking about mineral production, processing agreements, marketing contracts, and whatnot. That'll be listed on the engagement letter. These are sort of general documents that we typically see. Obviously, as the auditors come out and begin to discuss with the taxpayer exactly how their business is going, there'll be some refinement and probably some additional requests that are going to be tailored to your particular situation. Also included in the engagement letter is going to be a copy of the Taxpayer Bill of Rights. That actually is a statute. It's Wyoming Statute 39-11-102. So we give you a copy of that so you know exactly what your rights are. Following the engagement letter, the audit will actually begin. Some less complex audits can be done as at least what I call a desk audit, where documentation can be provided to the auditor electronically. Communication is done via phone or email. But for the more complex audits, the Department of Audit is going to want to come out and have what we call a field visit, do field work. The location of that is really going to be determined by where your accounting records are located, and maybe more importantly, where the personnel that maintain those accounting records are located. So even though you're doing business in the state of Wyoming, if those records and those personnel are located in California, wherever, typically start off with an opening conference between yourself and the auditors. And there'll be discussions about the scope of the audit, additional documentation, and whatnot. And maybe most importantly, initially, the auditors are probably going to want to have a walkthrough with you. And that walkthrough will be sort of an accounting walkthrough. We're going to want to see how transactions flow from the most basic invoice level through the accounting systems, and what sort of reports can be generated and whatnot. I'd also like to mention that in addition to having your accounting system and processes described to the auditors, it is also very helpful, and it may happen at a different time than this initial field work, that if you have specifics about your business itself, an explanation of that to the Department of Audit is very helpful. And I'm thinking in particular of mineral tax audits, where a large portion of the determination of where the point of valuation, taxability, and deductions occur is dependent upon what the production field looks like. So it is extremely helpful if at some point during this auditing process, someone can come in, whether it's through field schematics or even a personal tour of the production area, can walk the auditors through exactly what's happening out in the field, what the pieces of equipment do. All of that is extremely helpful in our determination eventually as we're working through the audit as to those underlying taxability determinations. So I would encourage those walkthroughs and those explanations to occur as soon as possible. Slide, if we could. So after the field work is completed, and I guess I should mention, when it is completed, generally the auditors are going to have a closing conference. And inevitably, there's going to be some documentation that still needs to be generated. Maybe some additional work is going to have to be done. There'll be a closing conference where we just make sure that everyone's on the same page about what additional things need to be done, both on your side and our side. After that, the Department of Audit and the auditors are going to come back to Cheyenne, and they're going to start putting their schedules together and building up the audit. And obviously during that time, there's going to be additional questions. So expect some emails and some telephone calls, and I'm sure some additional documentation requests are going to come back and forth as that happens. One thing that I want to mention that comes up relatively frequently are the idea of refund requests or amended returns coming in during the audit process itself. This is handled sort of on a case-to-case basis. In general, my philosophy, and I think the Department of Revenue's general philosophy, is that the audit itself, if it is engaged and the audit is ongoing, is that will take care of most, if not all, of the issues that may come through an amended return. So don't be surprised if an amended return is not processed because there's an ongoing audit. The rationale that the department will often give is that we're going to make a determination about the overall taxability and the buildup to that tax through the audit process itself, and that an amended return is not particularly helpful. The next thing that you will see that comes from the Department of Audit will be a preliminary issue letter, and it is just that. It is a preliminary take at the results of the audit. This preliminary issue letter will have gone through, obviously, the auditor, and it will have also gone through the Department of Revenue, the sole valuation authority. And it is our first run at what we believe the results of the audit are going to be. I have found that, again, particularly people who are facing audits for the first time may think that the preliminary issue letter is just kind of perfunctory. That's what the state is going to say, and we're just that's going to be what it is. And that's not necessarily the case. In fact, it's really not the case at all. The preliminary issue letter is really meant to be an opportunity for you as the taxpayer or client of the taxpayer to take a look and tell us what things we have wrong with the audit. This is an attempt by us to avoid litigation. So if you go through that and you identify issues, let us know. You can put that in writing. You can request a meeting like I was talking about before. We can sit down with you, the auditors, and the Department of Revenue, and we can work through these issues. So at least in my experience over the years, it's very rare that I find that a preliminary issue letter is identical to what goes out as final. There are almost always adjustments, and those are usually very helpful because I think it helps us avoid eventual litigation. So look through your preliminary issue letter. Feel free to tell us what you think is wrong, and we'll have a discussion about that, and we may be able to, solve a lot of problems that may otherwise go to litigation. The final thing that's going to come out after we go through that process of looking at the preliminary will be a final issue letter from the Department of Audit. That will be issued typically at the exact same time that the assessment comes from the Department of Revenue. So essentially, you're going to end up with two letters, one from the Department of Audit saying, here are the results of our audit that we've looked at, and another letter, an assessment letter from the Department of Revenue saying, we agree with what the Department of Audit has done. Here's your refund, here's your credit, or here's your additional assessment. The last thing that I want to talk about on this slide is involvement of attorneys in this process here. I would say, and Walter, jump in if you want, is that typically this is done without attorneys involved either on the estate side or on the taxpayer side. Most of these discussions work themselves out between the auditors, the Department of Revenue, and the taxpayer themselves. It is perfectly okay if you want to have legal representation at any point of this process. If it does happen, though, that means that I'm going to get a call, and myself or someone from my staff is going to show up, and that's perfectly fine. We can do that, but I just wanted to say that typically I find that attorneys really don't get involved until usually after the final issue letter goes out. But we're there if you need us.
I would just add, Carl, I totally agree with you on that. I think most of our work and advice during audits is usually just one-on-one with our clients, and we don't get involved in the conversations with the two departments. I have had a couple of cases where we've participated in the meeting that occurs after the preliminary issue letter. That's usually when it involves an issue that we are currently litigating or have litigated in the past. But as Carl said, one consideration is that if a private attorney is hired to join the taxpayer, that generally is going to bring the Attorney General's office into the meeting. Not always a bad thing, but something to consider.
And absolutely, I agree with Walter. Occasionally, we will have an issue that we are under litigation with, and it's helpful to have the attorneys involved with that. Or we may have a very unique issue, a unique statutory interpretation issue that we can look at, and you can look at and say, hey, this is something that is going to be appealed regardless, and we might as well start talking about it with the attorneys involved. And that's perfectly fine and acceptable, and it doesn't bother me at all. But I just want to let you know that I think some, again, taxpayers that are being audited for the very first time come in and think, well, I need to have some legal representation immediately during the course of the audit. That is not necessarily the case itself. So I think that takes us to our next polling question. What should you have prepared for an audit? And please, no one answer E. So that brings us to preparing for the audit itself. And there's not really a whole lot to say here because it is very specific towards your particular business. But obviously, you're going to want to have the records available to the Department of Audit that were identified in the engagement letter. And anything that has come up during the course of the field work and the sort of discussions you've had with the Department of Audit during the time. All of your accounting records, we're going to want to see a substantial portion of those. Underlying records may be asked for, contracts, invoices, whatnot. We appreciate seeing any and all of those that we request. I want to let everyone know that we are bound by strict confidentiality statutes. So you should not have any concern about that. Basically, the only parties that can see the information that you're providing us is the Department of Audit, the Department of Revenue, and myself at the AG's office. There are some other exceptions, but very few. So we take confidentiality very seriously. In fact, on the mineral side, the confidentiality statutes provide some criminal penalties as well. So we are very careful with that. So that should not be a concern for you in providing records during the course of an audit. In regards to records, we see all sorts. We see all the way from literally individuals who are keeping some rolled up invoices, if even that, literally in a shoebox, where we don't have any idea of how they're doing business, other than maybe some bank deposits. We see that all the way to very sophisticated taxpayers who have their own self-built accounting systems. And then we see everything in between. We see SAP systems. We'll see taxpayers that are working off QuickBooks. We see literally everything that's out there, and our auditors are trained to look at that stuff. So, just as long as you kind of show us how you do it, we should be able to figure out what information we need to extract from your accounting systems. So, what happens if there aren't records? And that's that becomes a problem for audits. Now, we have the ability to issue subpoenas, but I can say in the 23 years or so that I've represented the Department of Audit, we have probably issued as many subpoenas as I can count on one hand and still have a few fingers left over. It is not something that we typically do. It is only in those rare instances where a taxpayer is obviously trying to withhold information from us that we would even consider issuing a subpoena. Or occasionally we do have, I've recently had a taxpayer where they were under some federal regulations and they felt it the safest way before they divulged anything would be to have it done under subpoena. So those are the only cases that we really do use subpoenas. I know some other states, when an audit begins, the auditor essentially shows up with a subpoena as a matter of course. That is not the way that the state of Wyoming wants to do business in the tax sector. We don't want to immediately be in an adversarial position. So that's very unlikely. But if there aren't records available, whether they just don't exist or for whatever other reasons, the Department of Revenue does have the ability to issue what we call a BIA, a best information assessment. We prefer not to do that because it is essentially a guess. And we know that it's going to be wrong because it is a guess. But if we do not have the materials available to us to make a determination about whether we're talking revenue or we're talking deductions, that is our option, is to take our best guess and come up with something because we know something did occur. But we would prefer not to do that. So again, my recommendation is keep good records and provide them to us. One other thing in regards to records is that at times we understand that there may be a bit of a litigation after appeal happens, a tax appeal. There may be some additional questions that come from the attorneys on both sides. And we understand that, and that's fine. If there are some materials that we forgot to ask for that we need, we will ask for that in litigation. And if there's additional items that you may not have realized was needed by the Department of Audit during the audit, we will generally accept those goes during the litigation phase. We're not going to just say, hey, look, you didn't give it to the Department of Audit before it went final, and therefore you're out of luck. That generally is not going to happen.
Carl, could I jump in there for just a minute? That's exactly right. I've seen that happen. There's certainly a discovery process when we have an appeal, and that sometimes results in production of documents that were not produced in the audit. But one caution I would give on a related issue is there is pretty strong case law in Wyoming that if you're going to raise an appeal issue stemming out of an audit, you must have raised that issue with the auditor during the audit. So it's, and obviously appeals sometimes discover new issues or new angles on issues. But one word of caution is if you intend to raise an issue on appeal, it is important that you're raising that issue with the auditor during the audit.
It's a very good point. I agree. The next thing that's on the slide, that's easy. This is the 2 C's, communication and cooperation. And that's a two-way street. We want to be as communicative and cooperative with you, and we hope to have the same in return. And the more communication and cooperation that goes on during the auditing process, I think the quality end result is going to be higher. I know many times during an appeal is that we discover that the parties just simply weren't talking to one another sufficiently during the audit. And as the attorneys get involved and we're going through the discovery process, we're finding documentation and explanations that if they had been provided for prior to the finalization of the audit, it would have taken care of the appeal right away. So again, I would encourage everyone to be as open and cooperative as possible in talking to the Department of Revenue and the Department of Audit during the auditing process. The last thing that I have on this particular slide is payments. What happens if there is an audit finding and it is something that simply can't be paid without causing some severe hardship on the taxpayer? We understand that. We are not in the business of trying to shut a taxpayer down. I've seen this happen many times where, obviously sort of low revenue taxpayers have been going on and conducting business for years. An audit happens, they come in, they're educated. That's one of the goals of the audit about something they didn't realize they weren't doing, and they end up with a tax bill that could be several tens of thousands, if not $100,000 or more, and it's just they can't pay it without going out of business. The Department of Revenue, and this is part of the taxpayer bill of rights as well, we will work with taxpayers to put them into a payment plan if there's a severe hardship for paying those taxes. Now, the Department of Revenue, we can't waive taxes that are due and owing to the state, that are legitimately due and owing to the state, but we can work with taxpayers in order to get them into a payment plan that puts them on track to pay that off over a specific period of time. So if you're in that situation, feel free to talk to the Department of Revenue. We're always willing to talk and put something in place. Just remember that one of the conditions of any sort of payment plan, and it goes back to one of the goals of the audit, is education. We want to make sure that on a go-forward basis, that taxes are going to be reported properly on a go-forward basis. And as long as you do that and you can enter into some sort of scheduled payment plan, we're more than willing to do that for you. I think that takes us to our current tax topics.
And for the current tax topics, we are going to talk about minerals, excise tax, and ad valorem tax. Wyoming Statute Section 39-14-203, the imposition tax statute for oil and gas, provides multiple valuation methods, including comparable sales, comparable value, proportionate profits, the netback method, and the modified netback method. And for the netback method, that provides that the fair market value is the sales price minus processing fees and transportation expenses. The State Board of Equalization, as well as the Wyoming Supreme Court, as of last week, has heard appeals on if demand or reservation fees involved with a firm transportation contract with a pipeline are deductible as a transportation expense under the netback method. While creating certain exceptions, the State Board of Equalization has generally held that demand fees or reservation fees are generally deductible under the netback method. Additionally, the State Board of Equalization has heard an appeal on what the location of the point evaluation is for gas. Wyoming statute section 3914-203 also provides where that point evaluation location should be. If there's no processing facility, then the initial dehydrator is the point evaluation. If there is a processing facility that processes that natural gas in the field, then the point evaluation is at the inlet to the initial transportation related compressor, custody transfer meter, or processing facility, whichever comes first. The question of what constitutes a processing facility is fully briefed and in front of the State Board of Equalization, but it has not yet issued an opinion on that topic.
And these are interesting issues that we have, and I bring it back to what I was talking about before, is particularly when it comes to mineral taxation, a lot of it hinges on what is actually going on out in the field. What are those pieces of equipment doing? How are they categorized both by industry and under the tax statutes? And the more that you can explain to us, as the Department of Audit and Department of Revenue, as to what those pieces of equipment and how that production process is going on, the better it's going to be. Because while we do have some experience dealing with this, we're not necessarily engineers. And the further explanations that you can give us, I think is very helpful. And then, we can go talk to the State Board of Equalization and the Wyoming Supreme Court a little bit more from an education standpoint, better informed about that. So.
Well, thank you, Casey. And I wanted to just take a minute here and give a special thanks to Carl for joining us on this panel today. I think it's really wonderful, Carl, that you would join us in this discussion, and great for the audience to hear your perspective on these issues. Casey described a couple of current issues that we're seeing in the natural gas area. Really, our goal in talking about current tax topics is to give you a sense of the kinds of issues that we're seeing litigated today. Obviously, giving you sort of a superficial or broad description of these issues, but I think it'll give you a sense of what it is we're working on in the cases that we're litigating today. So I'm going to address a couple of mining issues that we have currently going. Before I do, I want to mention we do see there have been a couple of questions in the chat, and hopefully we'll have time to address those questions at the end. If we don't, we're taking your name down, and we'll definitely follow up with you individually afterwards, after our presentation. So thank you for submitting those questions. Now, on to mining. The first case I wanted to briefly describe involves mine methane. And as you may be aware, if you're working in the mineral industry, it is very common for methane, some quantity of methane, to be released during coal and other mining operations. And the case that we've got going on right now actually involves a trona mine, but again, this is pretty common for mining processes and functions generally. What's occurred in this case is there is a mining company that has actually been capturing the methane that is emitted from the mine and using that methane as opposed to simply flaring the methane. And the state of Wyoming, through the Department of Revenue, has taken the position that that capture and use of methane means that the methane needs to be taxed, is subject to the severance and gross products tax under the oil and gas statutes. And we are currently litigating that issue. It's the taxpayer's position that the oil and gas tax statutes, when you look at the details of those statutes, do not specifically impose the severance and ad valorem gross products tax on mine methane. And I'll certainly let Carl talk about the department's position on that issue.
Well, we believe that it is taxable, and we're fighting about that, but we're not going to do that here today. On this issue, I think, without going into specifics, to me, this type of thing comes up occasionally, and I actually find them fairly fascinating because companies are always innovating, doing something different. And that certainly is what happened here. This is a very smart taxpayer who decided, hey, look, we are venting out methane for safety reasons, and it has argued some value, and let's capture that and let's use that to our advantage. That's a very clever way to deal with that. Those are things that when these laws were initially passed, I'm not sure people were thinking of that. And these are, to me at least, some of the funnest cases to look at and to argue, because we're looking at sort of new technology, new ways of doing business, and then seeing if we can fit that into the existing statutes and the rules and regulations. And that's really what we're fighting about. And I find it fascinating. I don't know who's going to win, but these are the ones where these are sort of the natural issues that begin to percolate out of just the State Board of Equalization and will make its way all the way to the Wyoming Supreme Court. And I find them fascinating.
As do I. And, really, as Carl said, it really is a question of how the statutes address the facts that you find in the field. And I agree with Carl that these present some of the most interesting cases that we have, that we litigate or consider and discuss. Statutory issues, sometimes even constitutional issues will come into play with these appeals. That brings us to the next point on the slide, which is additional processing expenses. This is another active case that we have, which just examines really how the Trona valuation statute addresses processing. Trona is an incredibly important mineral to the state of Wyoming. We have a fairly unique statute when it comes to taxation of Trona, the imposition of production taxes on Trona. The legislature has imposed a fairly unique process. And the question in this case is, how specific processing expenses fit in to that fairly unique statute. I won't go in deeply into the details on that particular one, but again, similar to the previous case, it's a question of how the statutes work with the facts in the field. Both of these cases that I've described, both mining cases, are currently before the Wyoming Supreme Court.
I just want to briefly mention why we're just clearing up the minerals cases. For those who are listening, who are in the extraction business, there are a number of appeals that happen that really don't involve the attorneys on the other side. I just want to make sure everyone was aware of them. We have essentially volumetric issues that come up on an annual basis. We have, I call them mismatch appeals. They come in the fields of taking kind reporting, reporting to the WOGCC, and gross products versus severance reporting. Basically, we have situations where taxpayers are reporting, or different taxpayers, in the case of taking kinds, are reporting volumetric numbers that don't match each other where they should. And those generate a number of appeals that go in front of the State Board of Equalization. These are accounting issues, they're metering issues, and they are generally worked out without the involvement of the other side. But I just wanted to let everyone know that those do tend to pop up. I'm involved with those, unfortunately, but most of those get ironed out. And in the 23 years that I've represented the department, not a single one of those has ever gone to hearing. But if those do pop up, I encourage you to talk to the Department of Revenue. Basically, what we're looking for is someone to file amended returns to true up those numbers. And then that moves us on to excise. You want me to?
Yeah, we've got about 4 minutes left, so maybe we can touch on the highlights of excise and property tax, ad valorem tax quickly.
Very quickly on excise, we have several issues that are sitting out there. One are disputes about services to tangible personal property versus real property. So in the state of Wyoming, services to real property are not taxable, while those to tangible personal property are. So we have several disputes that are looking at that. That's an ongoing thing. I don't have time to talk about everything that's on the slide here. One thing I do want to talk about that comes up frequently with excise, and just to put it in everyone's mind, is the notion of separately stating invoicing for taxable and non-taxable transactions. We see this a lot on the excise side, where you've got a vendor who is performing both taxable services and non-taxable services. And during an audit, frequently we'll be looking at those invoices, and if those invoices don't separately state those items, i.e. they don't have a line item for the non-taxable transactions, it's all lumped together, those are treated as taxable. So that issue comes up frequently during the audit. And this goes back to the education part, is that following that audit, I'd encourage auditees, taxpayers to work with their vendors and to have them invoice out separately, so that going forward, we can distinguish what actions are taxable and which ones are not taxable. And then, ad valorem property, sure. I'll say from our side, from the Department of Revenue side, we have limited involvement with ad valorem. We assess for statewide properties. So those are usually industries that cross county lines. So telecoms, pipelines, railroads, airlines, some utilities. The Department of Revenue acts as the assessor in that case, because we don't want to have 22 or 23 different assessments coming from the different counties. So the state will come in and make those assessments. We're involved with those, and if there are appeals off of those, we defend those. In regards to local assessments, we are not directly involved with that. We do provide training and support for local county assessors, but they're the ones that are responsible for their local assessments and any sort of issues that stem from that.
Exactly right. And the issues that come before the county assessor, the elected county assessors in each county, are the property tax issues that affect everybody other than the state assessed categories that Carl described. The assessment comes from the elected assessor. If the taxpayer appeals, it goes to the County Board of Equalization, which is made up of the county commissioners. And one thing I would say, Carl mentioned the guidance that the department gives. Really important issue here is the Department of Revenue actually promulgates rules that the assessors are to apply in county assessments. It's Chapter 9 of the department's rules. Those contain not only the duties of the assessor, but also the specific valuation methods that are to be used in county assessment. So frequently in the appeals that we're involved with on the county side, we are referring to and relying on those department rules in Chapter 9. I think I'll leave it there.
And we are out of time, so we're going to take another 10-minute break until 10:50. I just want to thank Carl Anderson again for joining us on this panel here today.
My pleasure.
Welcome back. Next up, we have Bill Colgan, who will present on IRS administrative and case developments. Bill is a partner with Holland & Hart and is based in Jackson, Wyoming. He helps clients nationwide. Bill began his tax litigation career as a trial attorney in the tax division of the U.S. Department of Justice in Washington, D.C. He has been in private practice for around 25 years, and his practice focuses on representing corporations, partnerships, individuals, and other clients in complex IRS examinations and appeals. Bill also defends clients in federal criminal and civil tax investigations by the U.S. Department of Justice in U.S. attorneys' offices. He has represented clients in hundreds of tax litigation cases with appearances in state courts, U.S. tax court, federal district and bankruptcy courts, and U.S. courts of appeals. He speaks regularly throughout the country on tax controversy and tax litigation topics.
Thanks, Casey. Good morning, everybody, and thanks for joining us at our second annual Wyoming Tax Conference. We're really thrilled with success of the conference, and I've really enjoyed listening to everybody talk so far this morning. For somebody who grew up in Wyoming and went to other places and I'm fortunate enough to be back here, it's very interesting to hear what people have to think. And also sitting here in Jackson, it's great to hear what the rest of the state is thinking. In our world, so we do tax litigation and tax controversy. Most of it's federal, and we're representing clients from all over the country, and even some international clients. And it's been pretty quiet in Wyoming in terms of the activity of the IRS, and COVID has been part of that, but the budget constraints, and Sue Combs is going to talk about this a little later, but things are going to change. The IRS is investing now in resources. They really want to start up the audits of individuals, particularly wealthier individuals, and that's where the line of income is and wealth is. We've seen a lot of variances, but I fully expect in the next couple of years we're going to see increased activity in Wyoming, both from an individual perspective, corporate perspective, and potentially even criminal perspective, depending on what people have been doing in the state. So what's on our minds? What are we seeing as issues of focus? Certainly things like crypto and blockchain. Sue and I Sue was there in person. I attended virtually the ABA tax meeting last week, and you could not turn around without bumping into a crypto panel. And what was interesting about these panels is the number of government people on the panels talking about the issues. And it ranges from criminal concerns. The government has figured out how to trace things on blockchain, crypto, et cetera. And so they've got a bunch of tools that they're using now that allows them to pursue the bad actors. And it ranges all the way to people just not quite sure what to do with these issues because there's no guidance, and having to make decisions on behalf of clients that receive payment in crypto, et cetera, et cetera. And so the issues continue to grow, and the significance of it. And fortunately, we have expertise in our group to be able to address both in the tax group, but outside of the tax group, the demands relating to crypto, blockchain, and DOAs, the DAOs, the new organization that a lot of people are interested in. So we also deal a lot with just general civil issues, and so it can be just any range of things, valuation issues, and so that continues to be an issue. I know we're litigating a case in Utah on a valuation issue. We see a lot of transfer pricing. We spend a lot of time with transfer pricing, which is an international tax issue. And there's been a lot of disruption in the international tax space, both as a result of U.S. reforms that came in 2017 and guidance that have come after, but also what's happening internationally. And I'll get to that in a second. Micro-captive insurance companies continue to be an area of focus for the government. And conservation easements, so we're sort of on the tail end of the arc of that. It's been going on for a long time, but prosecutions have been happening and civil cases, and so it's a big area. We've also been working a lot in the area of regulation invalidity. And so it used to be that the thinking was that maybe the IRS regulations didn't need to go through the processes that, say, the EPA or other agencies had to go through, the Administrative Procedures Act. And the courts have made very clear that those rules apply to the IRS. And so there have been a number of attacks on regulations and many successful attacks on regulations. And I expect that to continue. And we've got at least one case in the pipeline raising that sort of issue. Most of our stuff is either pre-litigation, where we're dealing with either an examination or IRS appeals, or some other stakeholder involved in that process. Sometimes we escalate things up the chain within the IRS and speak to people who are not on the front line. But we do also do litigation. Our primary places where we litigate is in U.S. tax court and in federal district court. And most of what we file is in U.S. tax court. So that's where we spend most of our time dealing with U.S. tax court judges. And I can say that, Sue will touch on this more later. We're starting to get a visibility as to what the post-COVID world is going to look like in tax controversy and litigation. The return to court in person has been in fits and starts. And so I think, the court's going to continue to allow virtual appearances and recognition of a state like Wyoming, where it's very difficult for us to get to Denver for a trial. We now have an option that wasn't available before COVID, which is to have a virtual trial. So, I expect things might get a little easier to handle in that regard. And of course, the IRS will be coming back at some point. We still are not having in-person meetings with anybody. And so we're still on, we were on zoom.gov and we'll be switching to a new format with the government. And for security reasons, they have to use their own systems. But one area that is one that's been, sort of always out there, and I'm sure many people that are listening in today will have had issues surrounding this, and that's tax accounting. And I know I can lose people just by saying those words, tax accounting. And it is an area that's complex. And it involves accountants, it involves tax return preparers, and it involves the IRS, and it involves lawyers. And so there are a lot of people touching on these issues in the courts, of course. And basically, there are 4 accounting standards that come into play on a U.S. federal tax return of a corporation of any size. The first is U.S. GAAP, which is what a lot of companies use. The second is IFRS, which is the international accounting standards that are used a lot outside of the U.S. And then if a U.S. company has a foreign corporation, controlled foreign corporation, or a CFC in another country, that country very likely requires statutory books that might deviate from the prior 2 systems. And certainly might deviate from U.S. GAAP. So that's 3 accounting systems. And then when you look at the Internal Revenue Code, the IRS supplies accounting systems, accounting rules. And so you can look to like inventory accounting under 471, and you see that the IRS has created rules that in some instances deviate from GAAP. And so you have all these different systems, and the rules, and there's a case I'm going to talk about that I think is an important case. These don't come around very often, and it's gotten a little bit of attention in our world. Some very important people in the world of advisors on the legal side have recognized the importance of this case, and I think it's one that's going to be at least viewed as a initial step forward, if not a defining moment in understanding how to apply these rules. So accounting methods, you have to pick a way to account for something on a tax return. And for those of us that have been fighting the fight about accounting methods, and I think my first encounter probably was after the government, so probably late 90s, it's an area that's very difficult to figure out how it all works because you have a long-standing cases. There's a leading Supreme Court case and a bunch of cases that follow it. And so it's not quite clear because the cases are kind of all over the place. And there's a case I'm going to talk about right now that has actually tried to make sense of that case law. And I don't recall a case doing that in this way. And it's called Continuing Life versus Commissioner, and it just came out in April 6, 2022. And it's written by Judge Holmes. If for anybody who reads tax court opinions, the subset of us, we all know that Judge Holmes writes very colorful opinions and can be really fun to read. And he tries to tackle some really difficult topics. Okay, so first and foremost, we'll do the polling question number 8 here. And for those of you that seek CPE credit, you know the importance of doing the polling question. So we'll just go ahead and move on here. Do tax accounting issues keep you up at night? So continuing life involves these continuing care retirement communities. And it's something, I don't even think we have one in Wyoming. It's a relatively novel thing, but the idea behind it is you get somebody that's reaching retirement age, and they're starting to see that they want a place where they can live out their days, and they might start in an independent living situation, but slowly migrate to full care if that becomes necessary. And so a lot of people enter these continuing care retirement communities with the notion that they can ramp up the care as needs progress. And these entities are heavily regulated. And I know this case involves a California entity, Continuing Life Communities of Thousand Oaks. So the structure surrounding it is driven in part by the regulations of the state. That is in part what's driving the issues here. But in this case, the way these things work, so say I'm a resident that wants to come into one of these communities and I want to have an apartment or a house in this community. There are essentially 2 major fees that happen. One is I have to pay to get into it. It's this entrance fee. And I'll talk about that. That's where the tax issue comes from. And the second is like a monthly expense fee over time. And so, it creates some predictability for somebody going into it, so they kind of know what their expenses are going to be. But it also provides services beyond just a place to live. And so it's an interesting idea. Okay, so there's the big fee that happens. And during the years at issue, the fees ranged from $245,000 to $570,000. So this is like an upfront fee that's determined, the amount's determined based on the footprint, the size of the living space. And I happened to just look on the website to see what it is now, and it ranges up to $1 million now. So it's not an inexpensive situation. But that initial contribution doesn't go to Continuing Life, the entity, at the beginning. It goes into a master trust, and the resident becomes a grantee of the master trust. So this large lump sum payments going into the master trust. Of course, there's a trustee involved. And the relationship between Continuing Life and the trustee is the trustee can make interest-free loans secured by Continuing Life's property. And so it's a development. It's with buildings and residences and all that stuff. It also can be secured by the future money coming in. So it's a pretty secure loan arrangement between the trustee and Continuing Life. And the trustee goes and inspects the property and stuff like that. So it's a fairly close relationship. So what happens with that contribution amount when somebody dies or they decide to leave this organization? And this is where the tax accounting issue is. It's called the contribution amount initially in the case. And so this is the contribution amount that's being paid over. But then when the person decides to leave, the terminology reverts to a deferred fee. So it's the same dollars that's being referenced, except the deferred fee is now going to be paid between the master trust and paid from the master trust to Continuing Life. And that ranges from 5 to 25% of the contribution amount. And that's, of course, as I said before, when the resident either dies or leaves. So it could be 2 years after they joined, it could be 5 years, 10 years, etc. And then the master trust pays this deferred fee at the time that the resident dies or leaves. And then they continue to pay the resident's monthly fees until a new resident comes into that unit. And so the trust is actually doing something economically before the next step, which is the the remaining contribution amount gets returned to the person. So if it's 25% of the initial, the initial amount was $1 million, and there's 25% that was treated as a deferred fee that went to continuing life, then this person would get, or the state or the person would get $750,000 back. So, so that's what happens. So the real accounting issue is, how does continuing life account for that initial contribution? Is it income to them initially? Should it be amortized? And of course, it's not surprising that's the IRS's position, is that contribution amount that goes to the trust should really be recognized as income to continuing life. What continuing life did, though, was each year they would figure out, based upon the percentage of deferred fee, because there was a graduated schedule up to a max of 25%. And each year, the updated expected life expectancy of the person, based on actuarial tables, they would figure out the fraction of the deferred fee that should be incurred that year. And so they took it into income. And then, of course, when the person moved out or died, they recognized the remainder. Okay, so why did the IRS not like this? So from the IRS's perspective, they see this huge fee being paid by the person, continuing life being able to borrow against that fee, but it not being recognized as income except in just this fractional manner. And of course, there are expenses that are incurred, large expenses up front that are being incurred. And so they viewed it as a mismatch of income. The court ultimately disagreed with them on that, but the taxpayer ends up winning this case. And so that part in and of itself is, of course, remarkable, and the analysis of 451 and the timing of the income issues is very interesting in the case. Those rules have since been changed, but that is an interesting aspect. But the part that really has caught our attention is the discussion of the clear reflection of income doctrine. And clear reflection of income, for those of us that deal in my world of disputes, is a tool the government uses. It's a label that they'll attach to something on a statutory notice of deficiency to essentially replace your accounting method on a particular item with what they believe should be the accounting method. And newsflash, it's always an increased adjustment to income. And so this standard has been used as a tool against taxpayers. And so the cases have a huge range of cases on this. Sometimes taxpayers win, sometimes they lose. And then the standards that are used are kind of messy. And so Judge Holmes tried to make sense of all these cases. It starts with Internal Revenue Code 446, which sets forth the general rule that applies. So this is going to apply to any tax accounting that is done on a tax return, or any treatment of an item that involves an accounting method. The general rule is that taxable income shall be computed under the method of accounting on the basis which the taxpayer regularly computes his income in keeping his books. So that's what the statute says. So it's just this notion that you need to be consistent over time, how you regularly keep your books. So from year to year, you can't have these huge changes. And there's this whole regime of requesting a change in method of accounting that exists on the administrative side with the IRS to ensure that this is the general rule. But there are two exceptions. The first exception is if no method of accounting has been regularly used. Okay, we'll forget about that one. That's easy and rare. Or if the method does not clearly reflect income. What does that mean? Does not clearly reflect income. And are there extensive standards about when it's clearly reflected and when it is not? Has the IRS issued extensive regulations on this? And there are some regulations, but I wouldn't call them extensive. And the consequences of if you don't clearly reflect income, then the computation of taxable income shall be made under such method as, in the opinion of the Secretary, does clearly reflect income. So a lot of litigation has been around this. What does it mean to be in the opinion of the Secretary? And that would be Secretary of Treasury. But of course, we know that to mean the IRS. So if it doesn't clearly reflect income, then the IRS has the ability to come in and compute taxable income. In other words, impose a method, a new method that you didn't use, that in the opinion of the Secretary clearly reflects income. So Thor Power is the leading case on this, the Supreme Court case. And it really answered some, but not all questions. And so you have a whole bunch of cases that interpret Thor Power. And one of the line of cases that Judge Holmes has identified is the textual, following the statute, following the regulations, and following the words of the case law. And that may seem obvious, but there's been a huge shift in the judiciary in the last few years where a number of judges have come onto the bench that believe in this theory of interpreting things. The other approach was some courts tried to reason from the purpose of tax accounting and ask whether a particular instance of applying GAAP would lead to leave a cash-rich taxpayer with the opportunity to defer tax on the hoard in some improper way. What that is, that's almost like the result is too good to be true approach, which makes it very difficult for people who read the regulations to have some predictability. And so knowing that he interprets things as two kind of a break in the case law, one goes this way, keeping it close to the statute and regulations, the other goes the other direction of just kind of looking at the result and then working back from that. He, in this opinion, follows the textual analysis. And so he's keeping close to the statute and the regulations. And so what does this mean for us? Well, we know there's been a growing number of tax accounting cases. We also know that we anticipate that there will be an increase. And my thought is that when this 15% minimum tax rate goes in, so it's a worldwide minimum tax, when that rate goes in, it's already starting to be considered by select countries. The U.S. hasn't really made much progress because legislation has to be passed. That is going to raise a number of accounting issues. And my guess is that if the IRS does not get ahead of it with some guidance, that this clear reflection of income will be the tool to address issues there. And it could have an explosive effect on controversy. And I was just on Monday at the Pacific Rim Tax Conference out in Silicon Valley, where government leaders, U.S. leaders, accounting leaders from the Big Four, top advisors in my world that do planning, all of them anticipate huge intra-government controversies as well. So this is likely to be a big area. And I know we have one case involving, well, we have two cases actually, that I can't talk about right now because they're pending, involving clear reflection type concepts. And so, it's an area that we're dealing with archaic or very old case law. We're dealing with very old IRS guidance. The statute's old. The regulations don't really fit the current things. And I also expect that there's going to be a regulation challenge to the regulations that the IRS issued under this area. So it's an area that we're really watching. We're working actively in. And so stay tuned, see how it goes. Thank you.
Thank you, Bill. Sue Combs, another partner in Holland & Hart's Jackson office, will now speak on developments in tax controversy procedure and practice. Sue represents clients in complex IRS examinations and appeals, tax controversy, risk management, and resolutions of tax issues. She also litigates high stakes and complex business issues and has presented at hearings and tried cases before state, federal, and appellate courts.
Hello, everyone. Thank you for joining our second annual Wyoming Tax Conference. As my partner Bill just introduced our tax controversy group. I'm a partner in that group. I am also headquartered in the Jackson office, although we frequently are in our Denver office, and we represent clients across the country in industries as wide-ranging as our extractive clients, medical device clients, renewable energy, and IP, food and beverage, and just any industry that has tax issues, we generally get involved in. And in addition to our focus on controversy and litigation, the other thing that we're frequently involved in is helping clients, based on our dispute experience, identify and mitigate risk before a controversy arises. And we also defend and walk clients through IRS audits and dispute resolution efforts in front of the IRS. I am going to talk to you today about important developments related to IRS administration, and then the second half of my presentation will focus on some updates on case law. Last week, I attended the American Bar Association Tax Section's May meeting in Washington, D.C., and this gathers together top IRS officials as well as leading practitioners in a broad range of tax issues. And I, not surprising, attended the tax controversy track and learned a lot. And so I wanted to share with you some information that I learned there, as well as other information based on, this is the area I'm really interested in and regularly track what's happening at the IRS. So we're prepared to advise clients and stay on top of hot topics. So the IRS is a bit behind regular corporate in terms of return to office. They are just now starting voluntary return to the office after the pandemic. They are doing a staged return, April 25, IRS leadership returned, and then May 8th was the voluntary return of all employees. And it's anticipated that by June 25, there will be normal in-person operations for all employees. And as many of us have experienced, this is a new normal. And so they anticipate that virtual remote work from home and virtual meetings and audits with taxpayers will continue, and that the approach is a general increased flexibility of virtual and in-person operations. One thing that is a practical implication that Bill alluded to was that they are switching their video conferencing from zoom.gov. We have certainly experienced some hiccups with the zoom.gov, with appeals officers and just IRS officers in general having difficulty with zoom.gov. I don't know that that's the reason they're switching, but they are moving to Microsoft Teams here in the near future. The IRS does continue to use the digital communications tools that it's gotten familiar with during the pandemic. So that would include, for example, an continuing allowance of electronic signatures and continued use of virtual reading rooms for large cases that are document intensive. So let's move to polling question number 9. For those of you seeking CPE credit, what video conferencing platform is the IRS switching to? Zoom.gov, Skype, Microsoft Teams, or they are not switching. Okay, the IRS is also, as is typical this time of year, is undergoing a number of personnel changes. Some of the most notable changes are the creation of a new office called the Chief Taxpayer Experience office, and this is designed, well, it was envisioned with the Taxpayer First Act, and it's designed to alleviate a lot of the poor customer service that has been experienced by taxpayers over the years with the IRS in the form of delays in processing returns, delays in the ability to get somebody on the phone. So hopefully this new office will improve customer service. Some major personnel changes, the Director of Exam is changing, the Deputy Chief of Appeals is moving over to the SBSE division, and the Transfer Pricing Director of Field Operations, Brad Enwell, will be stepping in to that role. Another initiative that the IRS is focused on is hiring. They're on a tear in hiring agents and positions across the IRS generally. And with this, we should expect some increased enforcement activities and 10,000 general IRS positions. The Office of Chief Counsel, so the lawyers, are hiring an unprecedented 200 lawyers. That's actively ongoing. I know that they have filled a number of positions already. The Independent Office of Appeals is under active recruitment. They are seeking economists, lawyers, accountants, and people from a diverse range of backgrounds, and especially on the most complicated cases. There was a May 2022 report to give you a sense of why the IRS is hiring. From tax years 2010 to 2019, total audit rates for individual tax returns were decreased, and a lot of that was attributed to reduced staffing due to employee attrition and, of course, the pandemic, and years of reduced IRS funding. So talking about IRS funding, some recent legislative efforts to increase the IRS's funding is this HR 2471, the Consolidated Appropriations Act. That will increase the IRS budget by nearly $700 million increase over the prior year. We've also, many of us are familiar with the Build Back Better Act. That was passed by the House in November, but it's in flux in the Senate, so it's to be seen what happens with that legislation. But it's currently estimated to cost about $1.5 trillion to fund several social programs, and an important initiative in that legislation is IRS funding. So the Biden administration, what are their initiatives related to funding IRS operations? They have the fiscal year 2023 budget was released in March, and it includes a 12% increase over the enacted fiscal year 2022 budget. The general explanations of the administration's fiscal year 2023 revenue proposal, which is commonly known as the Green Book, was released at the same time with the budget. The Green Book is essentially the wish list for the administration of the tax proposals they want to implement to fund the budget. It includes a number of proposals that we won't get into today, but they are aimed at expanding the Secretary's authority with respect to tax administration. And just one example of that is a proposal to require the electronic filing of forms. And the IRS for years has been inefficient because they are a paper-heavy agency and inundated by paper. So the thinking is that increased movement towards electronic documents and filing will assist their administration. Moving on to a handful of notable developments that affect IRS operations. The first of that will be Revenue Ruling 2022-7. And this revenue ruling, what it does is it speaks to Section 6103, and 6103C involves the confidentiality of return and return information. So that information, taxpayer information, is confidential unless specifically authorized for disclosure by the tax code. And historically, there were less restrictions on government employees, but with the Taxpayer First Act, that was amended to make it clear that these disclosure restrictions also apply to government employees. The IRS is also requesting comments on what is known as Draft Form 15307. And this relates to the discontinuance of the continuous audit program. So large taxpayers are often subject to this former continuous audit program, which has been replaced with the launch of the large corporate compliance program. So essentially, the IRS is requesting comments on whether this, the disclosure principles under the continuous audit program should be discontinued. And this only affects a subset of companies who will continue to be in effect under a continuous audit. For those of you in the audience that may be subject to that, this form, they're asking for comments, not for much longer, just until June 2nd. Okay, another big change substantively with respect to IRS operations is research credit refund claims. A lot has been written about this already in the tax press, but I'll note it here again. And in September, the Office of Chief Counsel issued a memorandum where they set forth their opinion on what a claim for a research credit refund needs to include. And if it doesn't include this information, then it'll essentially not be accepted. And we won't be going through in detail each of these, but essentially it requires identification of significant more information than the regulations require. Several advocacy groups, including the American Bar Association, have submitted comments. The head of the Large Business and International Division of the IRS explained at the ABA meeting that these refund claims, these research credit claims are very fact intensive. So this was an effort to standardize the information that the government is receiving. They have not received many claims as of yet under this new standard. And so it remains to be seen what happens with it. And the IRS confirmed that this change is unique to research credit refund claims, and it's not indicative of similar enforcement efforts in different areas of the tax law. So another change is the historically, if a revenue agent wanted to raise an economic substance doctrine argument under the statute, he or she needed executive level approval to do so. That's because economic substance doctrine was considered new or very complicated and needed a higher level of review. That has now changed, and the typical level of immediate supervisor approval is still required, but that layer of executive approval to raise these type of penalties is no longer required. Okay, another interesting development in March relates to the Freedom of Information Act request. We have experienced significant delays in the IRS through our FOIA requests, and it appears by this memo that the IRS is taking steps to address their failings in making timely responses to FOIA requests. So this March 14, 2022 memo was circulated to all IRS offices, and it directs each office to ensure that their staff responds in a timely manner to requests from the FOIA Disclosure Office. And it also notes that taxpayers have a right to a copy of an opens compliance file without making a formal FOIA request. And the memorandum also identifies categories of documents where if a taxpayer makes a request for these documents, the relevant office in the IRS should not require them to make a formal FOIA request, and instead should exercise discretion and proactively provide the documents. So this would include final statements of agency policy and interpretation, even if it's not published in the Federal Register. It would also include final administrative staff manuals and instructions and formal training materials, as long as disclosure would not impair tax administration, which is a bit of a vague concept, but it still makes very clear that these type of documents can be made available without a FOIA request and the delay and cost that comes along with that. And so hopefully that will be a positive change in terms of making it easier for the public to get information that should be made publicly available from the IRS. Okay, we will move on to notable case law updates. So let's start first before we jump into our first case, and I'll tell you about some changes to the tax court itself, the U.S. tax court. Judge Kathleen Kerrigan has been announced as the new incoming Chief Judge of the tax court. And her 2-year term will begin on June 1, 2022. And the tax court judges elect the Chief Judge of the tax court. Another interesting development at the tax court is that the tax court has issued proposed amendments to its rules of procedure. And largely these changes are meant to conform to the rules in the federal rules of civil procedure. Some notable substantive changes in the tax court rules will be a more defined right to intervene in ongoing litigation, as well as the establishment of standards for when and how an interested entity can submit an amicus brief in support of an ongoing case. The court is accepting comments just for a very short remaining amount of time, and this link on the slide will bring you to the tax court rules should you want to look closer. And as you can see, I'm giving you a very high-level overview today of a lot of different things, and I encourage you, if there's something of interest to you on these slides, you will be getting a copy of them, and you can review them more closely or look up the information. So my goal is to give you a highlight of all of these interesting developments. That'll bring us to polling question number 10. Who is the incoming Chief Judge of the U.S. Tax Court? Is it the Honorable Morris B. Foley, the Honorable Albert Lauber, the Honorable Kathleen Kerrigan, or the Honorable Judge Toro? I'll give you just a moment to make sure you have an opportunity to answer that question. Okay, moving on to our first case of interest. This is the Beckler decision. And the United States Supreme Court in Beckler reviewed and reversed an 8th Circuit Court of Appeals holding. And this is interesting if nothing more, because the Supreme Court doesn't decide a lot of tax cases. So this is, we're always very keenly interested in what the Supreme Court says in tax disputes. And this case involved a tax court deadline and whether the failure to meet that deadline was excusable by the court, you know, if good equitable grounds existed for being late, or whether it was the type of jurisdictional requirements that meant that there was just no excuse available for missing the deadline. And the district court held that this requirement, the statutory requirement for filing a petition in tax court in a due process claim, I'm sorry, this is the tax court, was jurisdictional. And the Eighth Circuit, once the lower court decided that it was jurisdictional, and the Eighth Circuit agreed that it was jurisdictional, the Beckler Supreme Court decision held that it was, it reversed the Eighth Circuit. And so this case will have interesting and important implications for other deadlines in different contexts. Another case related to jurisdiction is the Treese case. And this involved the IRS's determination that a company could not be eligible for the voluntary classification settlement program, which relates to independent contractor versus employment status. And the tax court decided that it did, in fact, have jurisdiction. There are a number of APA, Administrative Procedure Act challenges, as Bill Colgan mentioned. This is a really important and developing area in tax law. So one important case is the Mann construction case. And these cases involve whether Treasury and the IRS need to follow notice and opportunity for public comment in order for a tax rule to be enforceable. And in the Mann construction case, they were dealing with a notice that required taxpayers to report their participation in certain trust arrangements. And the court held that the rule was, in fact, subject to the APA and was invalid for failing to allow notice and comment. Two more important APA challenges. The Hewitt case and the Oak Brook land case has created a circuit split related to a regulation involving conservation easements. The 11th Circuit held that while the IRS did allow for notice and opportunity for comment, they failed to address what it deemed a significant comment. And then the 6th Circuit looked at the same exact comment and held that it was not significant, and therefore the regulation was procedurally valid under the APA. So this has created a circuit split, and these type of APA issues are going to continue to be a big deal in tax disputes. Another APA challenge that's recent here in our home Rocky Mountain region is the Liberty Global case. And this case held that the IRS needed to follow the APA notice and comment procedures when it enacted a temporary regulation. And the IRS's long held position is that temporary regulations are not subject to the APA, but this case disagreed. And I'll cover one more area here, and that is timing of supervisor approval for penalties. There are several cases making their way through courts across the country about when the timing of supervisor approval that is required for penalties. And a most recent case in the 9th Circuit held that the IRS failed to comply with the supervisor approval requirement because it didn't have that approval before the 30-day letter was issued proposing those penalties. So stay tuned for these penalty supervisor approval cases because without proper approval, the taxpayer has a very strong defense against penalties. And with that, I will wrap up my presentation, and you will receive a copy of these slides. So I encourage you to look at any of the cases and information in more detail with those. So thank you very much for giving me your time today and joining our conference.
Thanks, Sue. We're going to take another quick break and we'll reconvene at 11:50. Next up, Dr. Nicole Choi will discuss the University of Wyoming's Low Income Taxpayer Clinic. Nicole Choi is an associate professor of finance at the University of Wyoming College of Business. She joined the University of Wyoming in 2009 and has been teaching and doing research in investment analysis / investment planning as her primary areas of interest. She obtained a Certified Financial Planner CFP certificate in 2016 and shortly thereafter started the CFP certificate program at the University of Wyoming College of Business. In 2021, she applied for the IRS grant to start a low-income taxpayer clinic and has been operating the clinic as the director since March of this year.
Thank you. Thank you, Casey. Thank you so much for having me here, Holland and Hart. Do you see me and hear me? I think so. As Casey said, my name is Nicole Choi. I'm the director of the Low Income Taxpayer Clinic, and I'd like to just share a little bit of the progress we made at the College of Business. And I would like to start by the overview of the program, LITC program. I think some of you are probably pretty familiar with the program. For example, Bill Colgan here, who just spoke earlier, started on LITC when he was in San Francisco. So obviously he's very familiar with the program, and I'm assuming some of you are as well. So with the risk of boring some of you, I would still like to start with the overview of the program and what it is about and what we are supposed to do, because these clinics, the LITCs, are supposed to be closely following the missions of the program and perform these activities. So the as you can see from the name, low-income taxpayer clinics, LITC, assist low-income individuals and individuals who speak English as a second language. The LITC program is the federal grant program that provides up to $100,000 per year to the qualifying organizations. Those are typically legal aids, other legal organizations, academic clinics at the law school or business schools, and other nonprofit organizations under a shared mission to protect taxpayer rights. The LITC program office is a part of a Taxpayer Advocate Service, TAS, we call an independent organization within the IRS. The LITCs receive a partial funding from the IRS, yet we are completely independent of the IRS. This is a matching grant, which means that we also, the organizations, the grantees also come up with the matching amount, at least up to the grant amount. So what do LITCs do? How can LITCs help the taxpayers? The LITCs have these three-pronged missions of representation, education, and advocacy. Representation is probably the one most of you are familiar with. The clinics can represent taxpayers in audits, appeals, collections, a dispute before the IRS, and in some cases, tax court. The LITC can also help taxpayers respond to the IRS notices and correct the account problems. So that's the representation part of it. By helping these low-income taxpayers, usually over 90% of the low-income taxpayers do not have a representation. So by helping them resolve the disputes with the IRS, we can achieve the better outcomes in cases. And really, most importantly, we help them, the taxpayers comply with their responsibilities. And education is also very similar. Education has a very similar goal as well. We help the taxpayers understand the U.S. Tax system, which all of us know can be very confusing. And again, as I said, the education of the taxpayers help them comply with their responsibilities as taxpayers and to be a responsible citizen of the community. The advocacy part is the goal of it is to identify a systematic inefficiency in the tax system. One example would be, so this topic came up while I was also actually at the tax section of the ABA last week. And one of the topics that consistently come up in this field is the earned income tax credit, which is a refundable credit. It's been around for more than 40 years. It's a significant value to the low income population, yet it comes with a really high percentage of errors. For example, about 26 to 28% of the returns filed with the earned income tax credit has an error. So the taxpayer advocate service published the research showing that the EITC was claimed on 17.2% on the individual tax returns in 2018. The numbers are a little old, a few years old. So I'm curious to see what the numbers look like right now. But in 2018, the EITC was claimed on 17.2% on the individual tax return. And as an amount, it was a 3.6% of improper payments or a tax gap. Yet the returns with EITC comprise of 70.6% of all audits in 2018, up from 48% in 2005. So we can see that there is disproportionate audit of the returns that include EITC, even though EITC, the amount-wise, it's a very small portion of the tax gap. So TAS made some recommendation to Congress and to the IRS to change the systems. One of the recommendations they came up with was change the way that they audit these returns. So for example, the correspondence audit comprises of 400 to 500,000 audits involving EITC. And they show how inefficient correspondent audit is, especially to people who don't have resources, because they showed that 25% of the people who received this letter did not even understand that they were under audit. So they identified this disproportionate and inefficient system, so that they can help people who don't have a representation and hopefully the achieving the goal of ensuring the fairness and integrity of the tax system. So that's what the programs do. A little bit about the clinic at UW. We established the low-income taxpayer clinic this semester, this spring, getting the grant of $75,000. The grant is up to $100,000 per year, but it's common for new clinics to not receive the full amount. So I'm hoping they will receive the full amount next year. And we are operating out of a University of Wyoming College of Business, myself as the director, and Jennifer Kreiser as a CPA and qualified tax expert. And we would not be able to do this with the help that we've been getting from the Department of Accounting and Finance, the college, and the community organization partners. And one of the biggest partnerships that we established, in my opinion, is with Holland & Hart. So the Holland & Hart tax controversy lawyers, including Bill Colgan here, Sue Combs, and Richard Shapiro, have been critical in starting Willie, the clinic, and also helping us navigate through these cases. The mandate of the grant requirement, we are mandated by the grant requirement to have the tax expert, which we have, and also someone who could appear before the U.S. tax court, which we don't have on our staff. So Holland & Hart tax controversy lawyers are helping us tremendously in that area. And also Sue Combs especially have been really instrumental in identifying the organizations, the community organizations that we could reach out. For example, I've since after talking to Sue, reached out to the Equal Justice Wyoming, 122 Resource Center, and Legal Aid Wyoming, and Voices in Jackson. A lot of these places in Jackson, we are realizing that Jackson is going to be the biggest clientele base that the clinic is going to see based on the non-English speaking population and population working at the tourism industry. So that's we are at now. We have about 5-6 cases. One, we are closely working with Holland & Hart. We just had a first interview with really the first client. As I mentioned, we don't really have the representation experience, so it's been really helpful watching the Holland & Hart lawyers deal with the clients. We just had an interview with Sue Combs and Rachel Shapiro, and I decided that I want to be Sue Combs when I grow up. But it's been really helpful. And 6 clients might not be a lot for some of you, but for us, each client is very exciting because one, we are supposed to serve the clients, so we have a certain number of clients that we need to be serving. And when Wyoming had, I forgot to mention one thing. Currently, we are the only LITC, the state of Wyoming. Wyoming did not have an LITC for several years. So the taxpayers who needed help, who could not afford to pay for the system, had to go to another state. University of Denver LITC being a primary places. So it's really exciting to be able to help these people. So each client coming in is really exciting because 5-6 clients is 5 more clients who could get help who were not able to for the past few years. And also it's exciting to be able to serve the clients with the help that we have. That's all I got here. I have the contact information of myself and the clinic here. So really the biggest help that I can get, I think, from all of you is to spread the word to the community organizations that you are working with, and also let me know if you have an idea on the pockets of the communities throughout the state of Wyoming that I can reach out to, and I would be happy to visit all these communities in person or do Zoom or virtual meetings, anything like that. That little QR code, if you are inspired by what we are trying to do here, as I mentioned, we are operating under the matching grant. Most of the matching comes from the personnel supports, like my salary and my CPA salary, but we are still required to come up with a cash contribution. So if you're inspired by our missions and our dedication toward the community, you can just point your smartphone right there. It's going to lead to the donation page. If not, just feel free to reach out to me if you have any questions, and have a great rest of the day.
Thank you, Dr. Choi, for agreeing to join us as a presenter today. I'm excited to watch the clinic grow, and I have to agree, I also hope to be Sue Combs when I grow up. Next up, we have Sarah Harradon. She's a partner in Holland & Hart's Denver office. She will present on wind and solar project tax credits. Sarah is a leader in fund formation, corporate, merger and acquisitions, master limited partnerships, and real estate deal teams. She works closely with other lawyers in the firm to achieve clients' transactional goals. So I'll turn it over to Sarah.
Thanks, Casey. And thanks for everyone for sticking with us this through the rest of this conference. I appreciate I'm kind of on the back end, so you probably are tiring a little bit. But I think we have a great presentation. I have a great presentation today that I'd like to share with you on the fundamentals of production and investment tax credits for wind and solar projects. I'm sure many of you have seen lots of coverage in the tax press and otherwise lately regarding green energy initiatives. They're specifically a fundamental priority of the current administration, as well as various proposals have been introduced in Congress, although have yet to really go anywhere. But this, there's generally been a renewed interest lately in renewable energy projects. And so I thought it would be a good time to cover the fundamentals of the two most popular renewable energy tax credits. And those are production tax credits for wind projects and investment tax credits for solar projects. So we're going to cover those two credits, what they are, how you claim them, and then we're going to touch a little bit at the end of the presentation on proposals in Congress to enhance and extend those credits. All right. Did I get my cursor here? And so let's start with what are tax credits generally. So tax credits are a dollar for dollar reduction in federal income tax owed. So if you have, for example, if you owe $100 of tax after you've calculated, you calculated your tax owed on your Form 1040, and you have a $50 tax credit, that tax credit reduces the tax owed, so that now you only owe $50 of taxes. What that shows, of course, is that in order to take advantage of tax credits, you need what we call tax capacity. You need to you need to actually owe taxes. There are lots of taxpayers in this country, of course, that don't, at the end of the year, owe taxes. They have a net operating loss, for example, that will carry forward, but they don't actually have what we call tax capacity. The other limitation on tax credits are with respect to the at-risk and passive activity rules. And those rules are very complicated, and we're not going to get into how those rules work technically, but they apply generally to individuals and closely held corporations. And that includes individuals that own interests through pass-through entities such as partnerships or S corporations. But those rules can dramatically reduce the benefits of tax credits. So you often see a lot of currently tax credit projects are owned by C corporations, not closely held C corporations that have large tax capacity. I will note here, in case we don't get to it later, that some of the proposals in Congress, as well as by the administration, add what's called direct pay. And that is the ability for taxpayers that are engaged in activities that generate renewable energy income, renewable energy tax credits, to apply directly for a refund for the amount of the credit. So you wouldn't have to have tax capacity to take advantage of the credits. Those proposals, as they currently stand, also don't appear to apply the at-risk and passive activity rules. So it's just a note that if we do get reform in this area, it's very possible that the breadth of taxpayers that can take advantage of federal income tax credits in these areas might dramatically increase. So that brings us to our the first credit we're going to talk about, which is production tax credits for wind facilities. So these credits are generally based on the amount of electricity that's produced by a wind facility. The wind facility has to actually be owned by the taxpayer. So that's another important point to make about federal income tax credits. Generally are only claimable by the person or the entity that owns the asset or the project that are generating the credits. You can't sell and buy federal income tax credits, and specifically production tax credits or investment tax credits, the way you might be able to go buy a carbon offset credit on the market, or other types of REC credits that people buy and sell. You can't. You actually have to own a piece of the property for federal income tax purposes, which you can own through a pass-through entity. The electricity produced must be sold to unrelated persons, and wind facilities are actually eligible to claim in lieu of the production tax credit an investment tax credit, but generally it usually ends up to be more lucrative or more beneficial to claim production tax credits, whereas solar projects are not currently eligible under the current rules to claim production tax credits. So the credit is claimed over a 10-year period, production tax credit, starting with the year that the wind facility is placed in service. The credit amount is based on the PTC rate for the year as published by the IRS, which rate is adjusted for inflation. The current rate is 2.6 cents per kilowatt hour. But importantly, under the current law, there's a phase out in place for wind projects. And that means that the phase out is based on the year in which the wind facility begins construction. And that's a term that we'll talk about a little bit later. But so if a facility begins construction, you can see here on the chart in 2016 or previously, it's eligible for 100% of production tax credits. Whereas if a facility begins construction, for example, in 2018, it's only eligible for 60% of the production tax credits. So you can also see from this chart that it jumped. It was 60% in 2018. It went down to 40%, and then it jumped back up in 20 and 21. Well, that's a pattern that is pretty typical with respect to renewable energy tax credits, and it's the result of Congress sort of making decisions with respect to the rates for these credits at the very last minute at the end of the year. So what you get oftentimes are developers and projects that are scrambling at the end of the year when Congress has said, oh, we're going to increase the rate for projects that begin construction in this year. You get folks scrambling to begin construction in that year. It also, you can see here that there's just a lot of uncertainty right now about what the rate will be. Will Congress wait till the end of the year and increase the rate? You can also see that it's projected to go away for projects that begin construction and beyond 2022. So we'll talk a little bit more about it with respect to solar investment tax credits, but there's just been so much uncertainty in this area for a long time that I am hoping, and I know a lot of others are too, that legislation will be enacted that at least can provide some certainty for a set period of time for taxpayers. So that brings us to our first polling question. What are the phase-out percentages for wind projects currently based on, which we just talked about? And I'm not going to read the answers, but they're up there for you. So please take a moment to answer the polling question. I'm going to speak really loud in case somebody's just has this on in the background. If you would like CPE credit, okay, moving on. So a quick example of how you would calculate a production tax credit. A taxpayer begins construction on a wind project in 2017, sells 2,000 kilowatt hours of energy from wind sources in 2022. The production tax credit is the amount of energy times the phase out percentage for projects that begin construction in 2017, which happens to be 80%, times the PTC rate for 2022. So next, we're going to talk about the investment tax credit for solar projects. And unlike the production tax credit, which of course is based on the amount of energy produced, the investment tax credit is based on the amount of the tax basis of qualifying energy property that's placed in service during the taxable year. And that really means the cost. How much should you spend on qualifying energy property? Qualifying energy property is generally tangible property that is used as an integral part of the facility. That means that it's used for the production of the electricity, the panels, a transformer, etc. But it doesn't include generally, ancillary buildings on the property or transmission property. The property must be original use. Generally, it can't be used. It can be created by the taxpayer, but it can't be used. The credit period for investment tax credits is a one-time credit. It's not, the production tax credit again is claimed over 10 years. This is a one-time credit that's claimed by the owner, again, the owner, or the lessee. Investment tax credits can actually be passed on to a lessee of property. In the year the credit is claimed, in the year the property is placed in service. So that, I think, raises the question, well, I'm going to generate this large credit in 1 year. What if I can't use it? And generally, the credit can be carried back 1 year or carried forward 20 years. So subject to certain limitations, but so it's not generally usually lost forever if you can't use it in the year it's generated. Importantly, investment tax credits, unlike production tax credits, are subject to recapture. Recapture means that the taxpayer has to take into income the amount of the credit previously taken if certain events happen. And those events really are if the energy property no longer qualifies as energy property, or if the taxpayer disposes of the property, or even, if the property is transferred as a result of, a default on a mortgage, etc. And that recapture period is 5 years. So it's 5 years starting from the date that the property is placed in service, and it decreases, the recapture amount decreases by 20 years or 20% with every full year after the property is placed in service. So for the first year, the recapture percentage is 100%, so on until it's 0% after 5 years after which the property has been placed in service. The other unique feature of an investment tax credit is that you have to decrease, the taxpayer has to decrease the depreciable basis of the energy property by 50% of the amount of the investment tax credit taken, unless it's passed on to a lessee. So let's do a quick example that's easier. So a taxpayer takes a $100 investment tax credit in the year it's placed in service. The taxpayer also has to reduce the tax basis of the property for depreciation purposes by $50, or 50% of the amount of the credit taken. So thus, the taxpayer has less depreciation deductions to take with respect to the property. So similar to wind, to production tax credits for wind, the amount of ITCs are generally based on the year in which the project begins construction. There's also a phase out for solar projects, which are up here. But unlike wind, any project that is placed in service after 2025, regardless of when it begins construction under the current laws, are only eligible for a 10% ITC. You can see here too, I mean, again, it's reflective of extender bills and, Congress changing these rules over and over again. You can see 26% was the rate for, 3 years in a row, 3 years in a row, which was a result of last minute changes in Congress. A quick example of how investment tax credits would be calculated: a taxpayer begins construction on a solar project in 2020. $2 million of the property is placed in service, is qualifying energy property and placed in service in 2022. The investment tax credit is the eligible basis, which I've told you is $2 million, times the ITC rate for construction for projects that begin construction in 2020, which is 26%. So for both of the investment tax credits and production tax credits we've talked about, the amount of the credit is based on when the project begins construction. And that is a term that is defined in a series of IRS notices, beginning with Notice 2013-29, where the IRS has provided that there are 2 methods a taxpayer can use to establish that construction has begun. One is beginning physical work of a significant nature. And that really just requires a taxpayer to actually do physical work on the project that is significant, not measured by the amount of work or the amount of money spent on the work, but significant to the generation of power or integral to the project. You can do the work on site if you own the property already, the land to which the project will be placed, or you can do it off site if it's performed by a contractor. For example, if you're going to start work on a customized transformer. But the work between, if you do work, but if the taxpayer itself doesn't do the work has to be done pursuant to what's called a binding written contract that has a number of requirements that are in the notices. And thereafter, the taxpayer must maintain a continuous program of construction, which is an important requirement for both of the methods that you can use to establish construction has begun, that once you start construction, you have to generally make continuous efforts to complete the project. So the other method that a taxpayer can use to establish construction has begun is the 5% safe harbor. And this is really just, you have to spend a certain amount of money. You have to pay or incur 5% or more of the total cost of the energy property by the end of the year in which you're trying to establish construction has begun. Any costs that are properly included in the depreciable basis of the project are generally included as part of the numerator and the denominator. You can imagine here, though, you've got, as I was explaining at the beginning of the presentation, that Congress has a number of times extended the rates at the last minute. So you've got taxpayers scrambling, trying to spend 5% by the end of the year. If you're ordering, for example, turbines, you're not going to have them delivered by the end of the year. So there is a special rule that I put up here for accrual-based taxpayers that generally allows you to pay or incur an expense and receive the goods within 3.5 months and be treated as if you incurred the expense when it was actually paid. So again, once you establish construction has begun under either method, you must make continuous efforts to finish the project, and that is referred to as the continuity requirement. So there's the requirement to begin construction, to show you've begun construction, and then the requirement to continue. Continuity is deemed to be satisfied if the project is placed in service within 4 years of the time it begins construction. And that's important because if you don't meet that continuity safe harbor, you have to prove by the facts and circumstances that the project was in continuous construction or continuous efforts were being made until it's placed in service, which can be a very onerous due diligence, or even record-keeping requirement. Certain delays are permitted if you're under the facts and circumstances test, permit delays, weather delays, labor shortages, there's various delays that are permitted. But I think most people try to take the position that they're going to meet the safe harbor. So that brings us to the last part of the presentation, which we're going to have to fly through a little bit quickly. But how familiar are you with the Build Back Better Act? Never heard of it. I'm somewhat familiar, or I wrote the bill. So again, loudly, please complete the polling questions. All right, I'll give you a second to do that, and then I'm going to move on. Build Back Better Act was passed the House in November 2021. It is now, it stalled in the Senate. It's unclear if parts of it will be, used and passed separately. I think that's the case, and I think it's also the case from what I hear from my friends on the Hill that the ITC and PTC provisions are not as, anticipated to be the first part of the package. But I think the Build Back Better Act was essentially a compilation of the administration's proposals and various proposals that were in the House and the Senate, that have been in the House and the Senate, as to what changes we might be able to expect for ITCs and PTCs. And generally, they all propose extensions of the credits. And they also propose this refundability, which I talked about at the beginning, and which is referred to as direct pay. But they also impose the Build Back Better Act and most of the other proposals propose this new two-tier structure for ITCs and PTCs. And the first is a base rate that is applicable to all projects. And then that base rate can be increased depending on whether or not the project meets certain requirements. And some of those requirements can be quite onerous. So 2 of those requirements are that the project pay prevailing wages and have an apprenticeship requirement. So that's sort of what is generally the first step. And then the second step, or maybe a third step, is if the project consists of domestic content. So certain, the project is built with contents that were made in the United States, steel, etc. Or if it's the project is located in an energy or a low-income community. So I put those, the description of some of those requirements up here for your reference. But this is an interesting slide because it shows the proposal is that it's only, 0.5 cents a kilowatt hour for the base rate. And so, and even to get to the 2.5 cents, which, again, currently the PTC is 2.6%, you have to meet prevailing wage and apprenticeship requirements. And then to go beyond that, you have to meet some of the other domestic content or energy community, et cetera, requirements. So it's a proposal to increase the rates and make them more, extend them for longer periods of time. But there is a possibility that some projects won't qualify at all for a higher rate without investments, potentially significant investments. These are all generally the same for the PTC and the ITC, which is that they really would only apply, the proposals would apply only really to facilities placed in service after the date of the enactment of the Act, which has left a lot of projects, as you can imagine, in limbo. Should I place in service? Should I not? Should I wait for a new rate? Should I not? Should I begin construction? Should I not? So we have a lot of just uncertainty in this area, and I think a lot of things have been stalled out because of it. But you'll see, the prior phase outs, though, that we talked about under the 2 bills would be completely eliminated, but you would be subject to this base rate and bonus rate structure. So the other 2 slides are those proposals, which are very similar for solar ITC. And with that, I've gone a minute over, so I'm going to stop and thank everyone for listening and participating, and would encourage you to reach out to me if you have any questions or want to talk about any of this stuff further. Thank you.
Thanks, Sarah. Our final speakers today will be Rebecca Schrewer and Rich Keeley. Rebecca is a partner and Rich is of counsel in our Denver office. Rebecca provides advice to fiduciaries and families relating to the transfer and management of wealth. She frequently advises professionals and family trustees in Wyoming trust companies regarding fiduciary duties and trust administration. Rebecca also represents clients in probate and trust litigation. Rich assists high net worth individuals and their families with trust and estate litigation to facilitate the smooth resolution of estate planning and wealth transfer disputes. He represents clients in matters involving probate and fiduciary litigation, including disputes involving trusts, estates, and protective proceedings.
Thank you, Casey. Thank you all for still being around this late in the day. We really appreciate it. Hopefully this topic will be interesting and keep everyone's interest for this last 20 minutes or so. So as Casey said, Rich and I work a lot with Wyoming private trust companies, private family trust companies, which we'll be talking to you a little bit about today. And we'll also be talking to you about Wyoming, some of the attention Wyoming has been getting as a potential tax haven. So the first thing we're going to talk about is I'm going to hand it over to Rich to kind of take a step back and talk a little bit about what is a tax haven? What does that term even mean?
Thanks, Rebecca. Yeah, so I think before we go into talking about some of the specific attention Wyoming has got in the last 6 months and really a couple of years is defining what is a tax haven. I think it's easy to call something a tax haven. The news certainly likes to do it because it's an interesting idea to put out there and it gets people's attention. But when we really dig down and say, well, what is a tax haven? There are a couple factors. And so these are factors from the OECD, which is a global organization that looks at tax havens really across the world. And these are the 4 characteristics that are common among tax havens. So first, you've got the no or nominal tax on income within the jurisdiction. You've got a lack of effective exchange of information. And so that's really talking about exchange from jurisdiction A, that might be the tax haven, out to other jurisdictions. You've got a lack of transparency. And then the final thing is just there's no requirement for substantial activities or presence within the jurisdiction. So what's the traditional scheme look like? When we're looking at it from a U.S. taxpayer's perspective, it's going to look slightly different than we look at it from a non-U.S. taxpayer's perspective. But when we're looking at kind of a U.S. taxpayer, here's the kind of the fact pattern, and this is actually from a case. The individual can go online, set up a corporation, say in the Cayman Islands. They pay a fee, and there's a registered agent. You can go through the whole process. You then can wire your funds into a bank account that is established for that Cayman Island corporation, and then you start using that corporation to go ahead and invest in U.S. or other investments. And by moving the assets offshore and putting them into a non-U.S. citizen's account, so to speak, with a foreign corporation, you sidestep a lot of the withholding rules and a lot of the reporting rules that come along with income that's generated to a U.S. taxpayer. And so it moves out, the income flows back out to the Cayman Islands, and then once it's there, the Cayman Islands doesn't report that income back to the local jurisdictions. And there could be a variety of reasons, one of which is, this lack of transparency. The Cayman Islands may not even know who owns that corporation. So when we're thinking of a tax haven, where do we usually think of? And so I mentioned the Cayman Islands, but places like the Virgin Islands, Bermuda, Cook Islands, Panama, there's all sorts of places that we look at historically. I think if you were to look at what are the, quote unquote tax havens, there's none that technically match the definition for OECD's tax haven definition, and there's none that are on its list of uncooperative jurisdictions. But we see names like Ireland, Singapore, the Netherlands, more of in like the corporate context of planning for corporate taxes. But when we're looking outside of the U.S. and really looking back into the U.S., we can see that there are places that non-U.S. citizens view as tax havens within the U.S. And places include Delaware, Nevada, Alaska, South Dakota, and Wyoming has found its way onto that list. And so you're probably thinking, well, why Wyoming? And I think it's important to note that this is not a new attention that Wyoming has gained. In 2009, the Prime Minister of Luxembourg was testifying to a committee in the EU, and he called out, among other places, Wyoming as being one of the jurisdictions that non-U.S. citizens are using as a quote-unquote tax haven. So how does Wyoming fit into the definition of a tax haven? There's a couple things, really. The first one is, and I think most people here would appreciate this, is that Wyoming has positioned itself as a business-friendly jurisdiction, and I think that there has been no ill will behind that, but it has left some avenues that people can use if they want to use Wyoming improperly. One of the key places is the kind of level of detail and information that's required to be disclosed when you incorporate or form an LLC. If anybody's done it with the Secretary of State in Wyoming, it's a pretty simple process. There is no requirement to disclose shareholders or members. There's really limited amount of information that needs to be provided beyond the registered agent. And so that lack of transparency kind of fills one of these factors that we've talked about from the OECD. Obviously, Wyoming has no state income tax, so that kind of checks the other box. And then, there is likely a need for some activity within Wyoming, but it's not substantial activity. So you check at least 3 of those boxes, or you could arguably check it. And then the last one, the lack of exchange of information, this is not a Wyoming issue. And I think that's important when we look at the tax haven picture and we look at Wyoming. This is not the lack of exchange of information by Wyoming or the U.S. as a whole. It's not driven by Wyoming. It's driven by international tax issues. And so specifically back in 2010, President Obama signed the HIRE Act, which brought into place the Foreign Accounting Tax Compliance Act. And that was really targeted at U.S. citizens who establish overseas accounts and will invest through those overseas accounts. And it required those overseas accounts, so going back to my example of the Cayman Islands, to start reporting back to the U.S. if they've got an account that's established for a U.S. citizen and showing how much money is coming into that account. But what didn't happen, and this is the important thing to note, when we talk about Wyoming as a potential tax haven is the United States is not a party to a reciprocal or multilateral exchange of information. So what is happening elsewhere around the globe is that there are agreements and treaties among countries to do this both ways. And the U.S. only wants the information coming back so it can go after its taxpayers. But it hasn't taken a position requiring disclosure of information regarding non-U.S. citizens who have accounts in the U.S. And so this is a totally much bigger issue. So when people talk about Wyoming being a tax haven, it's really a question of what's the U.S. doing on the global level. And I think that's really where Rebecca's going to start chiming in here, that the attention Wyoming has been getting is not really deserved upon Wyoming. It's come up through really the international players that have been revealed as being present in Wyoming. Manage your slide here.
So Rich and I would be remiss not to mention this article that came out in the Washington Post, and sort of I feel like everybody has been talking about, both in Wyoming and people that I kind of talk with across the country. And so there's an article called The Cowboy Cocktail that came out in December of 2021. And it's sort of, in Rich and my opinion, sensationalized things in a way that is a little dramatic, quite frankly. And we want to walk through that a little bit and talk about the cowboy cocktail and what it is, and sort of how it's in some ways a very common estate planning structure. And so quickly, before we get started with that, please tell us if you are familiar with the cowboy cocktail. Are you aware of the article? And I'll give everybody just a few seconds to answer that.
And while you guys are looking at answers, there's a couple different names that these alleged tax avoidance or evasion schemes come up with. So Wyoming has the cowboy cocktail, but there's also the Panama scoop, which was when Panama was doing its or was accused of being a tax haven. There's the double Irish with the Dutch sandwich. So there's all sorts of names that come up, but I think on the grand scheme of things, we got a good name if we're going to have one. All right, we'll keep going here.
Okay, so it looks like we've got a mixture of folks that have heard of it and have not. So let's walk through it a little bit. So in the article itself, just to kind of set it up, the words that are used are, like I said, are very dramatic. It's that, there's a lot of concealed ownership and concealed transfer of money, that it's an extraordinary secrecy. There's no regulation. It avoids creditors, it avoids tax, and sort of paints these structures as something untoward or something just overly secretive and inappropriate. It doesn't go as far as to suggest that it's illegal, but there's definitely some colorful language, which I think we're all used to with journalism to begin with. And so, Rich, thank you. So the article itself was based on the Pandora Papers. So these are records that were obtained by this international consortium of investigative journalists. And basically, they're a nonprofit network of journalists out of Washington, D.C., and they obtained all of these records and really focused on a certain number of international, for lack of a better word, bad actors that they could pinpoint to having some connection to Wyoming. And Rich, do you want to make any other comments on the Pandora Papers and what that is?
Yeah, so a couple things. Number one, this is a very large leak as far as information, and it was leaked from some law firms and accounting firms, kind of the typical places where these things seem to come from these days. But thousands and thousands of pages, lots and lots of individuals. And for whatever reason, this article seemed to focus on Wyoming. And is that fair? I don't think so, because this is not as though the Pandora Papers leak involved solely Wyoming individuals or companies or other folks that were tied to Wyoming. This is a global set of issues, and for whatever reason it came back. You can go online, though, if you're curious. You can go online to the icij.org, and you can search through them, see them. You can search by name and find out who was where. And and they've engaged in a process of really mapping out the tax structures that people have implemented and how they've used different jurisdictions to do so.
And thank you, Rich, for that clarification. Yeah, it was a Wyoming article that focused on a few of the international clients. The Pandora Papers were obviously much broader. And so a few of these individuals that the article focuses on are sort of, you know, there's a suggestion that they are doing something illegal, although the article doesn't go as far as to say that, although these individuals are tied to folks that do some terrible things, you know, ties to the mafia, ties to potential intentional pollution of waterways, ties to a dictator, a Dominican dictator who mass murdered, you know, tens of thousands of Haitians. And so it kind of sensationalized some of these folks that are potentially using this structure, and then went on to imply that maybe Wyoming is doing something that it shouldn't.
Yeah, and I would add that, you know, these folks are documented to be kind of examples of individuals who've used the structure in Wyoming and established PTCs up in the Teton County area and other parts of Wyoming. And so, I mean, these folks are out there, and unfortunately it's attracted the kind of attention that I think Wyoming doesn't want or deserve. And people have used this, and I think that's the one part of the article that is very understated, is that although people have used this structure, they've done it appropriately according to Wyoming law and federal law here in the U.S. And then apparently they say they've also complied with their local jurisdictions as far as taxes go. Yet the article is remiss to kind of point that out.
So what is the structure? So here's a diagram for everyone to kind of look at the structure that the article is critical of. And this is an extremely common structure, not only in Wyoming, but in sort of estate and trust planning in general. Wyoming is unique because it allows a private family trust company. So that box at the top is a little bit Wyoming unique, and there are a few other states that allow that. But generally speaking, this is a very common structure. So the structure is as follows, as you all can see on the slide. You've got a trust that's sort of at the heart of it, and your private trust company acts as trustee. And then in the trust, a lot of times you'll have entities, and those entities are often LLCs, and maybe those LLCs, for example, on the side of the slide there on the left, just an LLC as a wrapper for investments, to allow investing across many trusts, to allow sort of consolidated investment management, very common. In the middle there, you might have LLCs that hold real property, that separate each piece of real property to sort of, you know, contain each piece of real property for asset protection if it's rental property, or, you know, or to organize things underneath the trust. And then finally, sometimes an LLC is used as a holding company for other entities, and that's done for certain purposes as well. So before we go on to the next slide and talk a little bit more about all of those reasons, I just want to make the point that you know, the article suggests that having a private family trust company makes things, you know, very secretive, and the family can run things in secret. Well, it's the same exact thing as if you had an individual family member act as trustee, which people do all the time, or you have a couple family members act as co-trustees. And so the fact that you can have a private entity that's acting as trustee is really no different when it comes to, you know, a privacy perspective. And the same thing with trusts. I mean, trusts are private. They're private in, you know, many jurisdictions. That's not something that's unique to Wyoming. And so it's a little bit of a stretch. I mean, we use this structure all the time for domestic clients and domestic planning. So, Rich, let's go on to the next slide.
Yeah, and I was going to add, I think nothing in this structure enables a company to avoid taxes. It certainly could make it potentially easier, but the bottom line is you have to have an individual who is wanting to do that. Because the creation of a private trust company in itself is not a tax avoid or evasion mechanism or scheme or anything. And the same with these LLCs. I think everyone is familiar and would recommend using LLCs for businesses or other kind of just holding companies. And as Rebecca mentioned, the trust itself is not unique. And so this structure that they're calling the cowboy cocktail could be put in almost any other state, with the one kind of caveat being the private trust company is unique. But private trust companies, they are registered with the Secretary of State. You could subpoena them. You could do all the same sorts of things that you would do with any other type of company. So I think it's important to know there's nothing really controversial about this structure.
And Rich, will you mention that example from the article where they talked about Wyoming creating limited liability company law?
Yeah, and I think this just goes back to this article, which is unfair of Wyoming, that they are suggesting that because Wyoming was the first to enact the LLC Acts, that Wyoming did that with some sort of intention to help people conceal their identities. And it goes so far as just to say, you know, that this structure is now widely used across the country to help conceal the identities of owners and protect assets from creditors. And sure, a certain extent of that's true, but that is not really the motivation here. And again, as we all know, LLCs are everywhere at this point. So it's not really a fair criticism of Wyoming.
So going on to the next slide, we have listed here a number of reasons for this structure that are used in trust and estate planning all the time. First of all, people use these structures for wealth transfer and discounting. You know, people might use a holding company, an LLC, so that they can break it up into pieces and discount those minority pieces and transfer those pieces to irrevocable trusts to transfer wealth during their life, and that's a very common technique. People may use the structure for asset protection, and there's nothing wrong with that. Like I said before, you might want to separate out a rental property or something where you don't want that that asset bleeding into another, and people being able to access wealth across the board. And also used for family succession planning. A private trust company is a fantastic way to create and establish an entity with policies and procedures and structure for family succession planning and figuring out how those trusts are going to be managed for many generations to come. And it allows family control and involvement, which a lot of families want, but they want some sort of structure and way to manage that in a way that things don't go, you know, shirt sleeves to shirt sleeves in 3 generations, as they say. And so private trust companies are used for that as well. And Wyoming, Wyoming has some special features that are really useful in trust and estate planning. One is income tax benefits. So Wyoming has no state income tax. So you can create a non-grantor trust and situs it in Wyoming and get that tax advantage. And that's a very common planning technique, and there is nothing untoward about that. And Wyoming also has very settler-friendly trust laws, which I think is appreciated by many clients and used by many clients to allow flexibility to create structures that will manage their wealth for many generations in the way that they want to do it. And so we have tons of clients that want to take advantage of Wyoming settler-friendly trust laws. And then finally, privacy. There's a lot of negativity around this idea of lack of transparency or privacy based on these different structures, but there's a lot of legitimate reasons why people of significant wealth want privacy. And Rich made a couple good points earlier when we were talking about this. So, I mean, Rich, do you want to just kind of elaborate for a second on that, you know, privacy is not always, it's not a bad thing.
Yeah, and I think it comes back to this idea that there's the concept of tax avoidance and tax evasion. And a lot of these individuals are household names, and they can attract attention of all sorts of bad people. And it's beyond just this idea that they're going to create a trust company for evasion of taxes. You may have folks, particularly international, that come from jurisdictions where there's less stability, and they're going to want to move assets to a stable jurisdiction, such as Wyoming within the U.S., where they can kind of establish the banking relationships and have access to different markets that they may not have in other places, and also kind of separate their assets from unstable political environments where a new dictator might come in and kind of wipe out all the people that were supporting his predecessor. So there's a lot of legitimate reasons, and I think to kind of highlight your mention about the income tax benefits, there's nothing improper about you know, taking advantage of the laws that exist to minimize your taxes, but that's different than evasion. And I think there's a lot that can be said for people who might be critical of the state, its trust laws, its LLC laws, or what else there might be out there, that there's nothing really improper about this structure and what people are doing to get there.
So oh, sorry, go ahead, Rich. Do you want to do this one?
Yeah, so moving on to this last slide. So if we do accept this idea that perhaps Wyoming is a jurisdiction that is favorable or favored by people who are looking to evade taxes from outside the U.S., there's a couple things that are coming that are going to impact a lot of that idea and impact those four factors. So thinking back, the lack of transparency, the exchange of information, little or no taxes within the jurisdiction, and then that final aspect, which is the no substantial presence. These are kind of the areas where we are seeing activity or have seen activity. If you're not familiar with it, the Corporate Transparency Act has been passed and regulations are still being worked on, but it's going to require the disclosure of all beneficial owners, which are going to be shareholders, officers, directors, members of any organization formed by a filing with the Secretary of State. So this idea that Wyoming's regulations maybe are permissive and don't require a lot of information when you organize, that's going to kind of all go out the window. The same with the Anti-Money Laundering and Bank Security Act rules. They're broadening these rules with potential applications to private trust companies. It's a little up in the air as there really haven't been any cases or interpretations of these things. But again, this would impact the proverbial cowboy cocktail. And then really the last thing is there is always the potential for a change in state income taxes in Wyoming. And I know it's probably very unlikely, but I think as folks heard earlier today, Wyoming needs to do something and figure out some way to kind of manage its finances going forward. So I think that puts us at the end of our time. And I don't know if there's any questions. Let's see. I think there's no questions. So I don't know if someone's closing us out today.
I am. Thanks, Rich and Rebecca. Thank you all for attending the second annual Wyoming Tax Conference. I would again like to thank our guest speakers. We will be sending out a survey requesting your feedback on the conference. We use the information that you all provided from last year's conference to improve the conference today. If you have any specific questions for the presenters, the contact information will be available on the slides that is provided to you. We hope you enjoy the rest of your day, and we will see you for next year's conference, if not sooner. Thank you, everyone.